They waited days, weeks, and months for the trial to end, and there was no end in sight. Dragged on and on and on, and many people wondered, when will it end? And it never did. People fought, had brawls, people were arrested, violence ensued in the streets. I don't know. I ran out of shit to say. I was taking a shower and I had all this shit in my mind planned, and then like I sat here and my mind went blank. Bro, look at me. I'm like, we're up late last night. I was in a deep sleep too this morning. My alarm went off and I'm like, damn, it's already time. Apparently they're starting late today too. They're starting at 9:30 today. But I was like, I could have pushed it back, but I was like, because people are here now. You know, everybody expected. I thought so too. 9 o'clock. So today is voir dire day. Voir dire. Voir dire. Meaning it's like a test run. And I don't know why they say voir. Is that like, what's that, French or something? Voir dire. Where did that come from? Voir dire. A preliminary examination of a witness or a juror by a judge or consul. I was watching the show Your Honor, and when they did a test run, they just said a test run or like a like whatever. So law French from Old French. Voiture, DRC. Voir dire. Old French, law French. Interesting. So they're going to do a test run today. And like I said, the test runs sometimes are kind of, it's interesting in the moment, but for me, I know that we're going to have to sit here and listen through the same exact thing over again. So it's kind of like, ugh. I don't know if they're going to take all day today. That's another question. People are kind of wondering. How's everyone feeling? Maddie's been doing really good. Girlfriend's still really sick. And me, I'm fine, I guess. I haven't caught anything. I'm like paranoid this morning, or sometime in the middle of the night, like I coughed or my throat felt funny or something. I'm like, oh crap, it's coming. But then I woke up fine, I guess. Oh, really, Perriette? Well, yeah, that's true. It's to decide if the judge is going to allow it or not. Bueller, what's up? Early. I can't believe I'm still shocked about this whole. I don't know if you guys have heard. I brought it up on the chase last night. One of a Secret Service agent was robbed in Los Angeles. I'm like, bro, how? Yo, what? And then I was like, maybe he was off duty or something. Like maybe he was just like, I don't know, at home chilling or some shit. But it says the attack happened while President Joe Biden was at a fundraiser at the Peacock Theater. Bro, this guy's probably like shitting bricks to the thief.
California are searching for the person who robbed a Secret Service agent at gunpoint on Saturday in suburban Los Angeles. This all happening as President Biden was visiting for a star-studded fundraising event featuring President Obama, George Clooney, Julia Roberts, and other celebrities. But it's not clear if this agent was assigned to the president's detail. News Nation's Kelsey Kernstein.
That's what I'm wondering. Was
is here with the very latest information on this still developing story. This has a lot of people concerned because we don't know if the person who attacked this agent knew he was an agent, or once again highlighting how dangerous things are in so many cities.
Yeah, you know, Nick, we're also learning from police that they say that there were multiple attackers involved here. They say that this armed robbery that it happened in a residential neighborhood involving a Secret Service agent in Southern California. So this incident happened around 9 in the evening on Saturday in Tustin, California. This is just about 15 miles from Disneyland. So police are saying that they recovered some of the agent's belongings, but we're not exactly sure how at this time. But the latest update from
recovered some of the agent's belongings, because I don't know, I could imagine like if I'm a guy, like we hit a lick and we robbed some guy. And then you find out it's Secret Service, bro. We're dropping everything out the window, dusting it, washing it, bleaching it, and throwing that shit out.
Authorities is that the robbers remain on the run this morning. So they were last seen fleeing the scene in this vehicle here on your screen. It appears to be a 2004-2006 Infiniti. We were also learning that the agent was off duty at the time that this happened, returning from a work assignment.
Okay, that makes sense, because I was like, damn, if he was with the squad and he got robbed, I was like, bro, that looks so bad. So he was on his own, I guess, off duty.
Chelsea, we have to assume that the agent was armed and maybe working for Mr. Biden, or we don't know, or what?
We don't exactly know if this was his detail, President Biden's detail, but we do know that he did try to defend himself.
Really?
We are learning from police that the agent fired at the robbers as they ran from the scene. In fact, we got a statement from the Secret Service reading, it's unknown if the assailants were struck. We are thankful that the employee did not sustain any injuries. The agent involved has not been identified.
And this is still an active investigation.
Correct.
Kelsey, thank you so much.
Thank you.
Thanks for watching.
Bro. That's crazy. I'm glad he's all right. Wow. Mamma mia. Anybody can get it. That's how you know it's not safe. Anybody. I mean, I know those robbers didn't know he was Secret Service, I guess, but anybody can get it. Wow. Next week, by the way, it's going to be a really busy week. So I gotta with the headphones, I'm gonna plug them in the second computer, and if it works, I'm just gonna do what people are telling me, just whatever, tape or whatever. If not, I'm just gonna buy. I'm not gonna go crazy with it. I'm just gonna buy some regular headphones because next week, and thank you, Lindsay, sent me this stuff. Thank you. Let me just tell her thank you. There's a lot of hearings. Let me see, I'm looking at it. Dale Warner. I don't know who Dale Warner is. The Michigan man accused in 2021 murder his wife, Dee Warner. There's a pretrial hearing. There's a lot of interesting stuff. Damn it. And then 3 things on Friday, next Friday. Alec Baldwin. So Alec Baldwin has I think he has a hearing. He was charged with involuntary manslaughter in the shooting death of cinematographer Helena Hutchins. Has waived his appearance. I want to see that guy in court at the hearing in Mexico regarding his motion for a court order excluding witnesses. Corey Richens, the Utah woman accused of giving her husband a drink laced with a fatal dose of fentanyl. Oh, I forgot about that. I mean, I never covered that story, but I had heard about it. Is it crazy? And then we got Brian Walsh. I don't know if you guys remember Anna Walsh. We covered her. This guy killed her, and I mean, I guess allegedly, but there were so many like evidence like that this guy did. Like he was seeing places, his receipts, his Google searches, which makes me think now this woman Karen Reed and Jennifer McCabe. So yeah, he dismembered his wife. I don't know if they ever fully recovered her body. I don't know if they got pieces of it or something, but that's next week too. Oh, and later today, we got to do something as well. I think it'll be interesting with regards to Savannah Soto update. Oh yeah, Melraz says law and crime chat is like a dogfight. Yeah, I popped in yesterday for a little bit, and maybe you're watching here on the screen right now. Yesterday was pretty funny. I jumped in for a little bit, and they were going at it. So this guy Raindrop says, my theory is ATF Higgins was involved. He was acting too suspiciously. He brought a lawyer in, disposed of his phone. He was stuttering and acting way too nervous in the stand. I feel like that's half of these witnesses stuttering and shit. What do you guys think of those text messages yesterday? Because I saw some people feel that like it's whatever. Every couple has that those arguments in the text messages, and I've had that. Of course, me. I've had that too. But I think it's kind of like that. Some people are trying to say it's the context, and also I feel like a lot of the people were saying that, oh, they were happy at the bar. There was no arguments here. There's no arguments there. There's how happy and smiles. All these people have good things to say. But it really is true. You never really know what's going on behind the scenes. And people do argue like that doesn't lead to murder or accidental death. Or it does. But some other people said maybe it was motive. Like maybe it's motive. Or a potential motive. Barrett says, did you hear Baldwin just released a video trailer of a new show of him and his family? Like, he's not worried about jail at all. Really? No. Richards. The case is sus. Good morning, Rizza Cat, Ronnie, Alyssa, just Linda. Proctor. Lundy says the text don't prove anything. Maybe if they brought that in first before all the reasonable doubt. I feel like she was trying to like almost to like kind of like hoping that this guy would be like, yeah, it's done or something, because she was talking to Higgins. I don't know. But then I don't know. She also was inviting him for out to drinks. Weird. And he accepted. So. You know what's crazy? Like when I think about sometimes, like I reflect about life, my own life, and even just these stories and stuff. And a lot of the times there's like alcohol involved. Isn't that crazy? Like what if nobody ever went out for drinks that night? Or people didn't consume the amount of drinks they did. People die over alcohol. Well, like not directly, but indirectly, I guess. Yo, Kimmy. Oh, that I was supposed to clip 2 things yesterday. It never happened. I was supposed to clip it. I got like tired or something. I was kind of relaxing. But you should have seen my reaction to that, Kimmy. That yesterday, it was at the very end of the day, like extended, because people were telling me about the whole kill me thing. Ooh, what just happened? Oh, and so I went and looked it up together with you guys on stream. It was so funny because I'm just like, how did you guys take that, the kill me thing? I was kind of shocked at first because it was so odd because he's like, the mic is here. See, this mic has a bunch of like filters, like software filters testing. I mean, if I say kill me, I mean, you're going to still hear me even with this, but the microphone they're using in that courthouse, I don't know exactly what type of microphone it is, but it's picking up a lot of sound. Like this shit is wide open. Kill me, kill me, kill me, kill me. These aren't really made to pick up so much around sound. Depends on the settings and stuff. But I thought my reaction was pretty funny because I just like I can't with this case. Like every corner is like something in this case. Karen Reed, you turn around, it's another thing. It's like every day is some shit. Yeah, chef lady. I can't be doing texts and calls. Oh, good for you, Wawalker. Sherlock says, well, she was talking to Higgins because her and John were having issues and John wasn't into her, it seemed, anymore. Don't blame her for that. Well, I think before the Higgins thing, let me tell you what, I feel like she gaslights a bit because the Higgins thing, before that, they had this vacation or whatever. I think that was it. And then on the vacation, she accused him, excuse me, of kissing a woman, a friend or something of his. I forgot the whole, was it Levinson or the cousin or sister? So many people I don't even know anymore. And she started accusing him. And I don't think he did it. I don't think he did it. They brought up the witnesses, the sisters, I think, or whatever, and they both said it never happened or occurred. And she kind of snapped on the woman too, I think. And so I even wondered right then and there if she just made that shit up to accuse him of shit to go look up for a reason. All right, so now I'm gonna go talk to somebody, even though it never happened. I'm just gonna make shit up. And then when they were having issues, she starts doing the whole thing again. Oh, if you tell me now if you want to leave. But I mean, they both weren't happy, I guess. I mean, clearly they both weren't happy. So Matt here, a lawyer that I like to watch on Twitter. Today's Tuesday. Damn, there's nothing. He said, I expect more Thursday. We got to wait till Thursday. Damn, because there's no trial tomorrow. And today's a voir dire. Here are a few key takeaways from today's text messages. Reed suspected there was another woman.
No living being should ever eat.
Wait, what is that?
Life. Good, real food is simple. It looks like food. It smells like food. It's what dogs are supposed to be eating. We really don't want people to think of feeding food like ours as spoiling their dogs. It's
interesting. So Reed suspected there was another woman. Karen Reed stated she was in a toxic relationship with John O'Keefe and his niece and nephew. She texted she was in Mansfield when she wasn't. That's interesting. I didn't even think about that. She texted she was in Mansfield when she wasn't. I really think those kids, after a while, got to her, taking on the responsibilities. I don't know how much she did or he did or didn't do, type of thing. I'm not watching the ads. Not the dog ads. But I could imagine it's probably frustrating maybe after a while. I found it weird to the night of that he died. The text messages about like, you left your kids, you're leaving your kids. I think it was like 2 messages. You left your kids, where's your, something like that. And I was like, did John really just leave his kids like that? You know, I don't know. Chris, I don't blame you. How do the witnesses know what was going on in their relationships, though? Yes, I don't know if I'm understanding it right, but yesterday the text messages came out. There was 2 situations, Brian Higgins, and then yesterday's text messages that I could think of. Because all this time it was portrayed like there was no issues. Like, that's the sense that I got. Like, the entire time in the beginning of the trial, they were trying to portray it like, oh, there's no problem. There's nothing there. Like, nothing happened. Like, there's no problems, no issues. I know they say every couple has an issue, but I feel like they're trying to portray that there was nothing going on. I mean, it's the same thing as like a guy's wife is murdered, and then the first person they're going to talk to is the husband, and then they're thinking, oh, did you guys have any problems? Did you have any issues? Did you get into an argument that night? You know, this is like basic shit that police ask. You know, did you guys have issues that night? Did you have issues recently? Were they seeing somebody? Well, whatever, you know. Little Woody. I kind of wish I covered that. I hear it's a shit show. It's kind of hard to cover anything with this trial, honestly. That's the only thing sometimes. It's really consuming. It's taking so long. Now, I didn't intend to go till July with this shit. Like, damn, bro. July. Well, let me see. This lady said something. She's a nice lady. She nice. Alex Murdaugh. I can't find her. Anjanette, was it Anjanette? Oh shit. Oh shit. Oh shit. Don't hit the dirt. Alex Murdaugh. Murdaugh. This boy not playing. Buster Murdaugh files defamation lawsuit against Netflix, Warner Brothers, Discovery over alleged connection to Stephen Smith's death. Oh, shit. That boy going, uh-oh. The lawsuit filed last week in Hampton County specifically names Netflix, Warner Bros., Discovery, Gannett Co., and other production and media companies over claims they connected him to the death of Stephen Smith, a one-time classmate of Buster Murdaugh. Ooh. The lawsuit outlines several instances where media... I'll have to get back to it. Oh, man. Then also Netflix series Murdaugh Murders, A Southern Scandal. It depicts a person resembling Buster Murdaugh carrying a baseball bat. Oh, I didn't know that. Damn! Referencing me as Smith's killer. I didn't watch that. Or did I watch that? I don't know. Is that a different one or is that the first Southern Scandal? Maybe I watched it. I don't remember that part. One example in the lawsuit, Warner Bros. Produced a series titled Murdaugh Murders Deadly Dynasty, which falsely suggests and subtly accuses Buster of murdering Smith. The suit references a 10-minute segment where Murdaugh is alluded to many times as Smith's killer. Damn, bro. Them boys coming. It's tough, yeah, right? Sioban. Buster Murdaugh. Maybe they'll settle. I don't know. They were kind of trying to say like they were lovers or something. With I remember with the Murdaugh and Stephen Smith, like it was like rumors, or they were trying to like, I don't know. Murdaugh Dynasty. Okay, I was checking out some stuff. Good morning. Good morning. What's up, Deborah? Be easy. April. Oh, that's awesome, Lundy. I still talk to. He's not really my stepdad anymore, but I still talk to him. He's still like, he texts me Happy Father's Day. We sometimes text each other on birthdays. We kind of like keep a little bit in communication, you know. He was a decent guy, pretty good guy, I guess. Charlie, good morning. Wendy, good morning. I saw the list move too. Yeah, everything was in sync. Oh, shit. Justin Timberlake arrested for DWI in the Hamptons. Uh-oh. For a night driving while intoxicated. He's scheduled to appear in court Tuesday. Oh, Lord. Oh, no way, bro. Okay, who was here yesterday when we talked about this ish? And I literally mentioned, oh my God. We talked about the recent, man, my mind's slipping. The lady that was murdered by this Salvadorian migrant here illegally. Rachel Morin. Previously, right? We covered that story, and yesterday I mentioned there was this 12-year-old girl in New York that got R'd. And guess what? They caught this sick F. Again, I don't want to start politics this morning, blah blah blah. But an Ecuadorian migrant believed to have entered the U.S. illegally in 2021, arrested for assaulting allegedly this 13-year-old girl. All right, there he is. Again. It's just out of control. Out of control, man. Out of control. Wow. And this guy, if you didn't hear the story, this guy apparently, she wasn't alone. She was with another 13-year-old boy. So this guy like tied both of them up or something. And then he did what he did to the girl. So it's like a never ending story, it seems like. So he entered the country illegally in 2021. Police found him after neighbors recognized him from wanted posters, held him down, and called 911. Salute to the community. I feel like that's what happened with one of the other ones. Not this. There was another one from New York as well. Well, the one that like he put a belt. He came behind a woman and put a belt on her, like on her neck, and like, made her pass out and dragged her by her car and then R'd her. The community caught his ass too. So salute to those people. Poor girl though. I mean, it just makes you think about like kids, or like you can't send them anywhere, not alone anyway. But when they're teenagers, they want to go out alone. They want to hang out with their friends and stuff. So what the hell? What do you do? Oh man. Shooting in Canada yesterday. Really? You know what's interesting? The slap, the splash pads, the splash pad shooter. Oh wait, they did reveal his name. They did reveal his name, but what's his picture out? Splash pad shooter. I mean, I only found like one tweet the other day when I looked. It's not in mainstream though. His picture's not really mainstream or anything. The 8-year-old boy that was shot in the head is making amazing progress. Oh, that's good. Unfortunately, 2 people did die though. The trial It's supposed to. It's supposed to be. It's a voir dire day today, but for some, they pushed it. They pushed back to 9:30 today.
Thank you. Maybe see the close down session.
22117, the Commonwealth versus Karen Reed.
All right. Good morning, counsel. Ms. Reed, are all of the witnesses here, Mr. Jackson?
They are, Your Honor.
I'd like to hear from Dr. Russell first. Are you both prepared to?
Your Honor, I'm so sorry. I could not hear you.
I would like to hear from Dr. Russell first. Is that her name?
Dr. Russell, yes. The order would be proposed based on scheduling Dr. Russell, Dr. Wolf.
Like audio's a little rough today.
Okay, then that's good because that's the order I prefer. So, all right. Do you have a CV for her? Good morning. Morning, Tori. Do you have a CV I could look at for her, please?
Let me see if I have it in my notebook.
Finally, somebody told Aunt Beth to speak louder. I can't hear you.
Yes, I do.
And she has not written a report?
She's not.
All right. All right, let's bring her in, please.
Your Honor, before we get started, can I get an understanding? We started to say it at sidebar the other day, and you said you wanted to put that off to get to the witnesses. But I need a little bit of an understanding of what the court's expectations are. My understanding of voir dire, which this seems unusual in terms of the timing of it.
So the understanding of the voir dire is this is for the Commonwealth's motion to exclude this testimony. All right, that's what we're here for, the Rule 14 violation.
Is that the same with Dr. Wolf and Dr. Renchler?
Well, I thought that would help both of you. The Commonwealth has nothing on that, and you say you haven't been able to even talk to them at all about this case.
That's correct.
So I want to find out if they have any credible, competent evidence to put forward. So we'll have a voir dire on them as well. But
So
for Dr. Russell, what we're doing here today is there's an alleged there appears to me to be a violation of the reciprocal discovery obligations of defense counsel regarding Dr. Russell. So let's hear from her today to see what the appropriate remedy is for this violation.
So my intention is to ask her the court understands my sort of guardrails. My intention is to ask her what her qualifications are, which is that's the basis for voir dire. And that's where I'm going to stop. I'm not intending to ask her what her opinions are, conclusions. I'm going to ask her if she's come to opinions and conclusions, but I don't want to have to examine her concerning her full opinions or full conclusions, what she's based those conclusions on. It's unfair. We've provided the defense the prosecution, everything that we need to provide to them in terms of disclosure. They've got the equivalent of a report. They've got a summary of what she's going to testify to.
When was that provided? My order was 1 week from the start of trial, right?
Well, we didn't, Your Honor, in fairness, they didn't even finish their discovery 1 week before the start of trial. So it's a little unfair for us to be put on the scene.
1 week from the filing of the certificate of compliance.
Well, I don't know when I can't remember. My co-counsel indication was the day before trial.
Okay.
So during the course of, look, trial is a dynamic thing. During the course of the trial, I did not know who Dr. Marie Russell was at the time that they filed their certificate of compliance. We then attempted to, and did, give them the reciprocal discovery that we were obligated to do after they filed their certificate of compliance.
When?
Within 3 days of that. We had been giving them information prior to that, but at least within 3 days of that. We've continued, so the record's clear, we've continued to get additional discovery from the Commonwealth in notices of discovery throughout the trial. They have not finished. In fact, during the trial, they interviewed Jen McCabe, apparently, had a full interview with her. Lieutenant Tully took a report, dated the report, and then they held on to that report until after she testified. The interview, the report, and the completion of the report were all done before her testimony.
Do you need to call her again?
Your Honor, that's not my, and I think the court understands, that's not my point. My point is not I need to call Jennifer McCabe back. I've done the damage that needs to be done on Jennifer McCabe.
Oh my God.
The point is...
I'm sorry, I missed that. You've what?
I've done the damage that needed to be done on Jennifer McCabe. I don't need to call her back. The point is that what's good for the goose is good for the gander. The Commonwealth doesn't get to stand in the position of piecemealing and feeding us information, reports, discovery throughout the course of the trial. And by the way, when we then got seminal information about an expert that we did not know about, never met, never heard of, within 3 days of that, we provide everything that we have about that witness to the Commonwealth. They can't then turn around and say, oh, well, it's all the defense's fault. So we want to have a voir dire, which means that the euphemism for that voir dire is we want to have two bites at the apple.
Okay.
We want to be able to completely cross-examine her, then go back to our expert, and if she testifies, cross-examine her again after consulting with our expert. That's two bites at the apple, and that's not fair. If the court wants to hear whether or not Dr. Marie Russell is qualified to testify about the arm injuries, that, I believe, is the parameters, the proper parameters of the voir dire, and that's what I'm prepared to do today. But I wasn't planning on getting into the substance of her testimony because that's been provided. And I don't think Mr. Lally should be able to get into the substance of her testimony because he knows what the substance is because, like I said, that's been provided.
All right, so I disagree. I'm going to hear from the Commonwealth on this. Is it Ms. McLaughlin or Mr. Lally?
He's on fire today, though. Oh, smoking.
Your Honor, just briefly in regard to what counsel was referencing with Ms. McCabe, it was not a full interview by Lieutenant Tully. It was and I don't have it on me at this moment, but I can give the court a copy of that report. But essentially it was Ms. McCabe met with Lieutenant Tully, looked at some video, and was asked a single question. That report wasn't available. I didn't have it until after Ms. McCabe testified, but it was given to counsel prior to Lieutenant Tully testifying, and there were no questions asked of Lieutenant Tully in regard to that. My issue, and you know, I wasn't asking for a voir dire as it proposed to, as it relates to Dr. Russell, is that we first heard of Dr. Russell on May 21st, which was, I think, 6 weeks into trial.
Right, so that's what I asked, and you told me it was 3 days after the beginning of trial, Mr. Jackson.
No, Your Honor, I said this at sidebar the other day, and I just said it again today. I let the Commonwealth and the court know about Dr. Marie Russell 3 days after I learned about her, which was the 17th of May. I think it was the 17th of May. I had never heard of her. I didn't know who she was. We made contact. I determined that she would be useful for the jury in terms of specifically the injuries to John O'Keefe's arm. I then had one conversation with her, then immediately, within 3 days of that, turned that information over to the prosecution. So I didn't say that I gave this over 3 days into trial. That's not what I said.
All right, but you were ordered to do it. Ms. Giannetti, what was the date? You had 1 week from when?
The day before trial. So it would have been, I believe, April 15th. So what we knew as of that day, we were required to turn over.
All right, I need to take a quick listen.
What? All right.
Wow. Okay. Kind of a hot start to the morning. I didn't think about what Jackson said, Action Jackson, what he said about 2 bites at the apple. That's actually kind of interesting. That's true that it is a little bit advantageous if you get to hear the whole thing, testimony, whatever it's going to come up, and you get to question and everything. And then when the witness actually takes the stand, and what he was saying is like, well, you get all this information, then you can go back to the experts and get whatever you need to get, and then you cross-examine this person. I mean, voir dires are totally legit. Wait, that's it? They're back? Huh? What you do? Action Jackson. I thought I saw online too this witness that they're talking about. Like people were like, "Oh, they had this person for 2 years or a year before or something like that." But it seems like they both have kind of brought things around May. But what the prosecution was saying, they didn't question the May thing with Tully and what McCabe. voir dire. And then the thing is, the voir dire was just supposed to be for this one witness, but now they got these 2 other witnesses as well added on because Aunt Bev says she wants to see if it's credible. So maybe we are going to be here all day. I thought it was going to be just the one witness, the one that's supposed to say, that it was dog bites or something. Or she took a phone call. Maybe.
Jim, the Commonwealth's motion, the Commonwealth's renewed motion first.
Wow.
Never mind, Jim.
Okay. Paper 360.
I've got it, yeah. All right, so the Commonwealth has moved that I exclude the testimony of Dr. Russell based on a violation of the reciprocal discovery obligations of the defense. So I do find that there is a violation of the reciprocal discovery obligations of Rule 14. And I'm quoting from the notes, the importance of this, the reporter's notes to the old rule. And as you all know, we're in the process of updating that rule. But the very integrity of the judicial system and public confidence in the system depend on full disclosure of all the facts within the framework of the rules of evidence. To ensure that justice is done, it is imperative to the function of courts that compulsory process be available for the production of evidence needed either by the prosecution or the defense. So, what we're here to do today is decide a remedy for this violation. And that's why we're having a voir dire. I am not prohibiting the Commonwealth from anything on their examination of witness Mr. Jackson. The alternative is she doesn't testify. So the Commonwealth has not received the appropriate discovery from this witness. So we're going to have a voir dire, and they can ask her anything that they think they need to ask her. So those are the parameters of this hearing.
As long as I know the guardrails, that's fine. I just to close the loop on the record, my understanding, and this Little can probably speak to this more intelligently than I can, but during the middle of trial, there was a witness that we had never heard of, we did not know and didn't have a report for.
Who is that?
Dr. Fowler, F-A-L-L-E-R.
Okay.
If the court remembers, he's buried in the middle of about 75 witnesses, so
he
testified to alcohol levels, et cetera, and protocols at the institution at Good Samaritan. And we didn't have that information either. We didn't throw a fit. They said, hey, we were going to provide this information in a timely fashion. As soon as we know that we're going to call him, he's got to be on our witness list. We didn't know one way or the other what he was going to say. We didn't have a report, and we went on about our business. That's what we were doing as well. And by the way, I would note that the notes and the report under Rule 14 require disclosure of information you have. I just don't want the court to think that we were sitting on information that we didn't turn over.
No, I'm not saying that. It's just, this isn't as if it were something that the Commonwealth brought up and you needed to scramble. This is entirely of the defense position. So,
I understand.
All right, so that's the big difference. So why don't you go ahead and call her?
Okay. May I be excused to call her?
Yes.
Wow. Mamma mia. Hot morning. That was kind of funny too. It is like there's a lot of witnesses. Alex Murdaugh, the prosecution called on a whole bunch of witnesses and then went into a financial thing. But, they felt that was part of it, but that really, really dragged on. Oh my God. All right, let's check out the witness. I'm curious. This one's, I think, an important one for them. Voir dire.
Just tuck your legs in.
This make me flash back to Your Honor. The
Doctor,
sure.
I ask that you be mindful to step up. I ask that you remain standing and face the purpose.
Okay. Sure, you solemnly swear the evidence given in the court, the case now and here, and show the truth, the whole truth, and nothing but the truth, so help you God.
I do.
It's safe to say.
Morning.
So I'm going to ask you to keep your voice up. Speak right into that microphone, doctor, okay?
Yes.
Thank you. All right, go ahead, Mr. Jackson.
Thank you, Your Honor. Good morning. Could you please state your name and spell your last name for the record?
Yes. Marie Russell, Russell.
And I'm going to echo what the court just indicated. The air conditioners are on, so please keep your voice as elevated as possible and maneuver the microphone however you need to, okay?
Okay.
Dr. Russell, what do you do for a living?
I am a retired emergency physician and forensic pathologist.
And tell me what education you have, going all the way back to the beginning, that qualifies you as an emergency physician and former pathologist before you retired.
Okay, well, I've had about at least 16 years of formal education beyond high school. Initially, I started at MIT, where I did my pre-med courses. I had always wanted to be a physician. And so I went to MIT for a year, took pre-med courses. And then I had an unusual life event in that my mother came down with cancer, and she subsequently passed away. During the time away, so I took some time off from school. During that period of time, I decided to explore another interest of mine, which was law enforcement. And so I took some courses in law enforcement, and I became a full-time police officer here in Massachusetts.
What years were you at MIT?
That was 1972 to 1974.
Did you go to the police academy?
I did. Once I became a police officer here in Massachusetts, I attended the Boston Police Academy where I graduated.
What year was that?
That was in 1977.
During the course of your training as a police officer, did you have any specialized training in hit and run and accidents and investigations?
Yes, I did.
And which agency did you work for as a sworn peace officer?
I worked for the city of Malden full-time for 7 years.
That would be from 1977 to 1984, approximately?
Correct.
During that time, did you continue your education in any way?
I did. So I took as many courses as I could from the Massachusetts Criminal Justice Training Council, which included a several-day course in hit-and-run accident investigation. I took courses in forensic photography and numerous other things. And then, and I also at the same time continued to go to college. And I did that part-time, where I eventually got a bachelor's degree of science in psychology with highest honors.
What institution was that from?
That was from Northeastern University.
And that was a Bachelor of Arts in Psychology?
I think it was a Bachelor of Science.
Got it. Subsequent to your Bachelor of Science degree from Northeastern, did you also advance your education further, formally?
Subsequent to, so yes, so I decided that I did want to pursue a medical career. And so I then attended medical school, University of Massachusetts Medical School full-time for 4 years.
Did you ultimately get a degree, an MD degree from UMass?
Yes, a Doctor of Medicine degree in 1987.
So you were there from 1983 to 1987, is that right?
That is correct.
And did you do a residency?
I did. I did 2 residencies, actually. Most people do 1, but I did 2. I did, my first residency was a combined internship and residency for 4 years. And I did that in Los Angeles at Los Angeles County Medical Center, which is a very big trauma center and what I would consider the Bellevue of the West Coast. Very busy.
You say that just because of the volume at USC Medical Center?
That is correct.
Is it one of the busiest medical trauma centers in the country?
Yes.
You were there from 1987 to 1991, is that right?
Yes, I did my ER internship and residency during those years. Yes, there.
During that time, were you seeing patients?
Oh, yes.
You're treating patients?
Lots of them.
You were attending to patients?
I was a trainee, so I was seeing as many patients as we could. There was always a waiting room full of patients, and yeah, so I saw many patients during that time period.
You indicated a second residency? Tell me about that.
Okay, so I still realized I had an interest in forensics, and so I decided that I wanted to also train in forensic pathology. So I did a second residency in anatomic pathology, 2 years, followed by forensic pathology fellowship at the Los Angeles County Coroner's Office for 2 years.
And the years, if that's 4 years, that would be from 1991 to 1995 approximately?
That is correct.
Tell me what your experience was as a fellow at the Los Angeles Coroner's Office, Los Angeles County Coroner's Office.
Yes, well, it also was a very busy coroner's office, and so every day there would be cases. I probably did at least 2 cases a day, most days, and plus conferences and educational opportunities. But the interesting thing about being a fellow is they try to give you a wide assortment of cases. So, for instance, I not only saw numerous victims of gunshot violence and stabbings, but I saw numerous victims of motor vehicle accidents and natural death, overdoses. And then if there was an unusual case, it usually went to the fellow, because the fellow was also being supervised. So,
did any of those unusual cases, and we'll get more into this in just a second, but did any of those unusual cases include animal attacks?
Yes.
Did you become a professor, an educator at any point?
Yes. So during my 29 years at LA County Hospital, during the last 25 of those, I was a assistant professor or an instructor, but mostly an assistant professor. And what that meant is that I was responsible for overseeing the care that was provided by the interns and residents. So when a patient would come in into the hospital, the emergency room, they were oftentimes usually seen by the intern or resident, and then I would go and subsequently see that patient also. So, and that was in addition to my own cases. So I'd see my cases and their cases.
And that was at LAUSC, correct?
That is correct. And
can I ask a quick question?
Yes.
LAUSC, for those of us who are not necessarily familiar with it, is that associated with the University of Southern California Medical Center?
Yes.
That's the school, in other words, the site.
Yes. So it stands for Los Angeles County / University of Southern California Medical Center.
And that's where you were an assistant professor for the majority of the rest of your career?
Correct.
Were you also an assistant or an adjunct professor at Cal State Los Angeles?
Yes.
Okay. For how long were you an adjunct professor there?
I believe that was 4 or 5 years. And I taught criminalistics, forensic medicine there. As
an attending physician in the ER, in other words, a supervising physician in the ER, can you tell us what some of your duties and responsibilities included, especially as it pertains to trauma? And then I'll get more specific in just a second. Okay. Well, so I would oversee the care of all the patients that came in during a particular shift. And that would include medical patients and trauma patients. And as I mentioned, it was a very busy trauma center. So we had lots of trauma patients, including the types of violence I described earlier that I saw at the coroner's office, but lots of motor vehicle accident victims because there was a highway there right nearby. There were a couple of highways, so a wide variety of accidents. Did your supervision include assessing, diagnosing, and treating patients? Correct. In terms of the middle part of that, diagnosis, was part of your job to determine the cause of injuries or to at least assess the cause of injuries? Yes, and I took that on a little bit more because I was interested in the forensics aspect of the injuries. The forensic aspect? Yes. Okay. During your time at LAUSC, even after you left the Los Angeles coroner's office as a fellow, did you continue to stay in contact with the coroner's office and have relationship with the coroner's office as a supervising physician?
I continued to stay in contact with the coroner's office, and I used to attend their conferences as often as I could, not as a supervising physician, but as a physician and a graduate of their program.
During your tenure at LAUSC, did you ever become the director of any programs at LAUSC?
Yes.
Does that include the director of Center for Life Support Training?
Yes.
What years was that, if you remember?
I don't remember that.
The early 2000s, late 90s?
Yes, that sounds about right.
Okay.
And we would conduct lots of courses, including trauma, life support courses.
Did LAUSC incorporate a quality improvement program?
Yes.
Within their institution?
Yes.
Did you become a director of that as well?
Yes.
So you were director of Center for Life Support Training and director of LAUSC Medical Center Quality Improvement. Is that right?
The quality improvement was for the emergency department. Yes.
And did you also become the director for jail medical services?
Yes.
What is the association between LAUSC and the very, very expansive jail system in Los Angeles County?
So LA County Hospital was unique in that they, many, many years ago, developed a jail, what they called a jail ward, which was a combined inpatient, outpatient, and ER. So there was a dedicated jail ER. And that has been in existence for probably about 70 years now. And patients that were placed under arrest by either LA sheriffs, LAPD, California Highway Patrol, or any of the municipal agencies in the area, and I think there were about 70 or more municipal agencies, could bring their patients to the LA County jail ward where the patients would get treatment.
Ultimately, you became the director of that entire program, correct?
Yes.
They're still going, huh? Jeez.
Did you also work with the State Medical Board of California in any capacity?
Yes.
Tell us about that.
For about 7 years, I worked part-time for the California Medical Board as a physician assigned to one of their enforcement teams. And I did that 1 day a week, and I did my other job at the county hospital the other 40 hours a week.
So you didn't take off time from your duties as an ER physician, as an emergency physician. This was in addition to you being an emergency physician.
That is correct.
Did you hold the title of Chief Medical Executive for the California State Prison System, specifically at Corcoran?
Yes.
Tell us about that.
So I retired from LA County Hospital, and I went on to move on to the the California Department of Corrections and Rehabilitation.
And what year was that? Did you make that transition?
So 2018 is when I started for the state prison system. Okay. And I worked there for 5 years as director of their medical service in Corcoran.
I'm sorry. So for that prison, within that system, you were the chief medical executive for the entire agency, correct?
That is correct.
All right.
For the entire prison.
Understood. Are you board certified in emergency medicine?
Yes.
Are you a member of the National Association of Medical Examiners?
Yes.
Are you a member of the American Academy of Forensic Science?
Yes.
Do you have any publications in the area? And I'm going to be very specific because you've been relatively widely published. Is that right?
Some people would say yes. Some people would say no.
More than a couple of publications.
Correct.
And peer-reviewed journals, correct?
Yes.
I want to focus your attention on animal injuries. Have you been published in the area of animal injuries specifically?
Yes.
Do you recall those publications?
Yes, they had to do with law enforcement dog bites.
Did you draft an article or co-author an article called Managing Law Enforcement Dog Bites in the ER?
Yes, I was a co-author.
1996?
Sounds right.
And that was a peer-reviewed article?
Yes.
Ultimately published?
Yes.
And ultimately available to be cited by other doctors and studied by other doctors, correct?
Correct.
Did you also author or co-author an article entitled Law Enforcement Canine Dog Bites, Injuries, Complications, and Trends.
Yes, I did.
Was that in 1997?
Sounds right.
Was that also peer-reviewed?
Yes.
And that publication was also available for other physicians throughout California and throughout the country to refer to for the study of animal bites and dog bites, correct?
Dog bites, yes.
Dog bites. Concerning animal injuries, during the course of your professional experience, how many patients have you seen, diagnosed, and or treated with animal injuries, including dog bites and scratches, if you had to estimate?
Many hundreds.
Would you say it's over or under 1,000?
I would say it's over 500. I don't know because we didn't keep really good records back in the earlier days.
But it's safe to say you've seen hundreds and hundreds and hundreds of dog bites and scratches.
Yes, in my 29 years at LA County Hospital.
He included all the other stuff and dog bites, but I was wondering how many dog bite scratches.
Hospital, yes, and my dog bites I took care of and dog bites that the residents took care of, yes.
And you've even published articles and studied, not just seen them, but studied dog bites and dog wounds, correct?
Yes.
Have you qualified as an expert previously in other courts as in emergency medicine?
Yes.
Have you qualified as an expert in other courts in forensic pathology and wounds?
Yes.
Has that been in both state and federal court?
Yes.
Doctor, were you asked to review certain materials related to this case?
Yes.
And that was in furtherance of coming to, if you could, come to an opinion or a conclusion about injuries to the victim in this case, a person by the name of John O'Keefe.
Yes.
What did you review in anticipation of your determining whether or not you could come to an opinion or a conclusion?
So I reviewed hospital photographs, autopsy photographs, an autopsy report, grand jury testimony from the medical examiner in this case. There may be some other
based on
items.
I just want to ask about that. Do you have notes with you as to what you reviewed?
No.
Okay, so when you say there might be other, you don't.
Well,
if he tells you what you reviewed, you'd know it.
I would recognize it.
All right, but I want to hear it from you. You don't know of anything else that you've reviewed? This is sort of important, Mr. Jackson.
Okay.
Can you think of anything else, Doctor, besides
autopsy.
these?
Autopsy photographs, autopsy report, neuropathology report, toxicology report.
No, so no
and the grand jury
notes.
testimony.
Okay, so as you recall, the items that you reviewed include an autopsy report by Dr. Scortibello, correct?
Yes.
A neuropathology report by a doctor named Stonebridge, correct?
Yes.
Toxicological reports associated with the autopsy?
Yes.
Grand jury transcripts from Dr. Scortibello?
Yes.
Photographs of evidence items, including a gray sweatshirt?
Oh, yes. Yes.
And autopsy photos that were taken attendant to the actual autopsy?
Yes, and photographs that were taken in the hospital, and I reviewed the hospital ER record also.
When they say notes, are they saying that she should have taken
So
like
in addition
notes,
to what you just listed,
like things that she found, things that she noticed, things that she done, like a record of things?
there's also hospital photos separate and apart from the autopsy photos, is that correct?
Yes.
And those hospital photos showed the injuries to Mr. O'Keefe's arm, is that right?
Yes.
And you also reviewed emergency room records that are attendant to his initial acceptance into the emergency room on January 29th, 2022, correct?
That's correct.
Based on your review of all of those materials, were you able to confidently come to any conclusions or opinions about the nature of the injuries suffered by John O'Keefe, specifically as they relate to John O'Keefe's right arm?
Yes.
What is your opinion and conclusion concerning those injuries?
Those injuries appear to be consistent with an animal attack.
Can you be more specific in terms of the type of animal, or are you relegated to simply an animal attack?
Well, they are consistent with a large dog attack. There's a combination of both what I consider bite wounds and scratch wounds on the arm. There were also some puncture wounds in that shirt.
And
so I'm sorry, puncture wounds in the shirt?
Puncture holes in the shirt.
And on what do you base the opinion that the injuries are consistent with dog bite or scratch marks?
Well, the patterns. There are several patterns of parallel wounds that appear to be superficial scratches that could have been caused by nails or could have been caused by teeth. There are different angles on the arm and different locations on the arm, and but they're generally oriented in a specific direction. And there's also an area, the distal forearm, which is close to the wrist, which shows what I believe is an arch area of teeth marks.
And what's the significance of the arch area?
Well, so the arch would be the front area of the jaw of the animal, you know, or the dog in this case, where the teeth tend to be close together and curved. There's a curved pattern to the configuration of the teeth.
I'm going to have just a moment, Your Honor.
Yes.
Holes in the shirt. We're gonna have to look at the shirt again. I'm gonna show you something that's probably gonna tick some people off. I don't know. I'm just curious what you guys think about this. Might have time. They had on Court TV. They had this analyst, retired Mike Gold, a canine expert. His opinion is John O'Keefe was injured. His injuries were not caused by a dog, but rather by a scavenger animal when O'Keefe was lying outside on the lawn. What do you guys think about that? Hell no. Oh yeah, maybe. Hell no, maybe. But then I saw somebody on Twitter arguing, well, why just the arms? If they were like picking
I'm showing you a series of photographs.
Maybe because there's blood.
May I approach you?
Yes.
First, can you describe whether or not you recognize?
I don't know.
What's depicted in that photograph? Have you seen that photograph before?
Yes, I have.
Is that part of what you reviewed in coming to your opinions and conclusions?
Yes.
What is that a photograph of?
So this is a photograph of the decedent's arm near the elbow. And do you want me to describe what it shows?
Just briefly.
Okay.
Of what
and it shows wounds.
Okay. Your Honor, I would ask that be marked as next in order of evidence.
Blizzard pig.
All right. So for this voir dire, we'll have separate evidence, right? Is this an exhibit number in the trial already?
It has not been marked yet, so I'm fine with starting over, sort of for the purposes of the voir dire process.
So this will be a separate voir dire with separate exhibit. Yes.
So it's going to be exhibit 1.
Yes.
I'm curious to hear what she has to say about, or her description of the injuries. This is a big witness for the defense. It really is. So this is a big deal for them.
This gets thrown out. This has been marked, but I think.
Hold on. Okay.
I'm so sorry.
No, go ahead.
This one of the three has already been marked, but if just for consistency, I'd rather mark it additionally for voir dire.
We need a separate record for the voir dire.
May I approach?
Yes.
This one's already been marked.
I don't know what kind of animals are out there. Is there? I don't know.
And if you'd tell me the exhibit numbers that they are.
Oh, and maybe that's why the pig DNA.
So you're putting these in now? There's no objection, Mr. Lally?
For purposes of this, no.
Oh,
okay. So
we're onto something.
We'll mark these now, but.
May I approach?
Yes.
one, the one with the label 2858 on the bottom, has previously been marked in the trial. I would ask that this be marked as the next in order for the voir dire.
But what I want is the exhibit number at the trial.
I'll get that for you.
Oh, I did hear that argument. You picked DNA from dog treats.
I believe it's exhibit 19.
Okay.
Oh, damn, Brandy. Maybe it was the pigs. No, that wouldn't make sense. The mouth. Or.
Is that 19? That's correct. It's 19.
Okay.
Oh, they got little nails on. Oh, no. I mean, they have a little sharp hooves.
And is the third one also in evidence, you said?
2 of the 3 have not been marked. I'll as soon as that court report is ready.
She's ready.
I'm ready. May I just establish the foundation?
How big was Chloe?
The following 2 photographs that I just showed you, Doctor, do you recognize those?
Yes.
Did you also review those in terms of, in furtherance of coming to your opinions and conclusions?
Yes.
Do they also appear to be different photographs of John O'Keefe's arm?
Yes.
I would move for the admission of both of those, Your Honor, for purposes of voir dire.
There's been no objection to them, so they're in. They're already marked.
I just need to know which one's 2 and which one's 3. May I approach?
Yes.
Yo, Lally is going to have to put in some work.
Okay.
I think. I don't know.
With court permission, may I publish
Yes.
Exhibit 2 for voir dire?
Yes.
Is this a photograph of the of John O'Keefe's arm?
Yes.
Is this one of the several photographs that you reviewed in coming to your opinions and conclusions?
Yes.
I want to ask you a couple of questions about this. There should be a laser pointer on the desk.
Oh. Okay.
Can you explain for the jurors what it is about the injuries that assisted you in coming to your opinion and conclusion that this is from an animal attack?
Okay, there's several patterns here. So, for instance, let's look here, right near the elbow, the exterior part of the elbow. There's these 2 linear marks, which appear to be from upper teeth, and 2 punctures below those, which are superficial, meaning they didn't go very deep into the skin, but they appear from the lower teeth. So that's one pattern. There's another pattern close to the shoulder, which shows parallel marks, these 2, and maybe a third one in the middle, parallel marks that are oriented at a certain angle, and these are superficial wounds, which are consistent with teeth marks. They also could be possibly consistent with nail marks, but
with what?
Nails from claw. Yes.
All right.
We have some more here, similar from obviously different teeth involved or different claws, and then down here, closer to the wrist, we have an unusual pattern of at least 4 striations, the way I see it, at least 4 striations that I believe are caused from the teeth towards the front of the mouth, near the arch. It appears that there's an arch pattern here. So,
in a dog attack or in an animal attack, in your experience, we can take this one down. Let's cover the ground on the 3 exhibits that we've already marked. Can we take a look at Exhibit 1? Is this just may I publish, Your Honor? Yes. I apologize. Is this just a close-up of the same injuries?
Yes.
And do these appear to be consistent with what you just testified to in terms of either teeth or claw marks, especially as it relates to the area closest to the elbow?
Yes.
All right. And then looking at Exhibit 3, May I publish?
Yes.
Those punctures?
Is this a close-up view of the area closer to the wrist that indicated those parallel, you used the word striations?
Yes.
All right, and these appear to be taken attendant to the autopsy as opposed to the other photograph, exhibit 2, that was taken in the hospital. Is that right?
That is correct.
All right. And would the time difference account for the slight change in the nature of the wound?
It could.
Photograph of the wound, I guess?
It could, or a different technique, yes.
Okay. Let me take these down.
Well, maybe it's hard to tell, I guess.
Did you take into consideration the lack, in coming to your opinion and conclusion, the lack of other injuries, for instance, fractures, broken bones, or deep bruising, soft tissue injuries?
Oh, yes.
How did that play into your opinion?
Well, so of course I considered, what else could have caused these wounds, before coming to my conclusion. And so I wanted to rule out other things. And there were no significant major bodily injuries that, outside the head. There was nothing, there were no fractures of the long bones, the chest, the pelvis, the arms. So, yeah, so having seen hundreds and hundreds of car accident victims and people hit by cars, I ruled that out very quickly.
Okay. And in terms of the injuries that you did see, especially as they're attendant to the arm, based on everything that we've discussed today, is it your opinion, based on a reasonable degree of scientific certainty, that those injuries are consistent with an animal attack as opposed to a motor vehicular pedestrian incident?
Yes.
Thank you. That's all I have.
Okay. Lally, what are you going to do?
All right, Mr. Lally.
Lally, what do you got? Looks good. Kill.
Good morning, ma'am.
Good morning.
I can take you back to, you were talking about some police training that you had received when you were in the academy or while you were working with the police department here in Massachusetts. Is that right?
Yes.
Okay, what kind of training what did that training consist of?
Well, I attended and graduated from the standard police academy at that time. And then I took additional courses that were offered from the Massachusetts Criminal Justice Training Council. And these were taught generally by experts in their fields, and they were on a variety of subjects that are listed in my CV, included, the hit and run accident investigation, forensic.
There, just for a minute, ma'am. Doctor, in reference to your training as it pertains to hit and run accidents, what did that training consist of?
Oh, well, mechanisms of how accidents occur, mechanisms of how to determine, what vehicle was involved in an accident. I don't, it was a long, long time ago, but yeah, so determining if people were struck by vehicles, what vehicle was involved, or if it was auto versus auto accident, what vehicles were involved.
And I don't mean to belittle this training whatsoever, but is it fair to say that that was relatively rudimentary training that you received in the academy?
Probably. I would not, yes, okay, probably. If
you don't have any training in crash reconstruction or anything like that, correct?
That is correct.
And am I correct in you indicated that you're board certified in emergency medicine, is that right?
That's correct.
And so you're not board certified in forensic pathology or anatomical pathology or any kind of pathology?
That's correct.
And the last time that you worked as a coroner, when was that?
The last time was in 1995 when I was doing autopsies for the coroner's office. I have since, though, consulted on some cases from the LA coroner's office.
What, about 30 years ago? Is that about right?
For autopsy, yes.
Now, have you ever testified in a case in which either Mr. Jackson or Attorney Little were counsel?
Not that I'm aware of, no.
And when was it that you first were contacted in reference to this case?
The first contact was May 15th.
May 15th of what year?
May 17th, excuse me, of this year, 2024. Yes.
Oh.
And you went through a list of things that you were provided and you reviewed, and you mentioned hospital photos, correct?
Yes.
Autopsy photos, is that correct?
Yes.
An autopsy report, is that correct?
Yes.
Grand jury testimony from the medical examiner, is that correct?
Yes.
A neuropathology report, is that correct?
Yes.
A toxicology report, is that correct?
Yes.
And then I think you also remembered some photos of some clothing items, is that correct as well?
Yes, a shirt. And
anything else?
Yeah, hospital ER record.
Hospital ER records.
Yeah, yes.
Anything else that you can think of?
No.
Did you ask for anything else to review?
No.
Were you told of any other material that was available for your review that you weren't then given?
Well, I requested that that I focus in on the wounds, so I didn't ask for a lot of material in this case.
But fair to say that you were looking for anything and everything, material to the wounds that you were asked to look at, correct?
Please say that again.
Sure. Fair to say that you would want to look at anything and everything that was related to the wounds that you were asked to look at, correct?
Yes.
And so, did you make any specific requests as to what material you were provided, or were you just handed some material or forwarded some material and you looked at what you were given?
No, I requested that I have the autopsy photographs, the ER records, the ER photographs. I requested those.
Now, you mentioned some articles that you had written that were published back in 1996 and 1997 related to dog bites, is that right?
Yes.
Are those publicly available articles?
Yes.
And in those articles that you wrote, you were talking about law enforcement bites, correct?
Yes.
So law enforcement canine bites typically involve what you would call sort of a bite and hold technique, is that correct?
Yes. Yes.
So is there a difference between, through your experience and the hundreds of dog bites that you've seen, is there a difference between what you would observe from a dog bite from a law enforcement canine versus just your domesticated dog?
Well, yes. Now, the study, one of those studies was over 700 dog bite wounds, and there were two techniques used at that time: bite and hold, and later on, bark and hold, or bark and alert, or something of that nature. So there are different techniques, but yes, to specifically answer that question, which was, are they generally different from regular domestic dog bites? Yes.
Now, did you write a report in regard to your opinion that you testified to here today?
No.
Why not?
I don't think there was much time, and I didn't know if I was going to be actually testifying.
How long would it take you to write a report?
I wasn't asked to write a report, excuse me.
Oh.
Were you asked specifically not to write a report?
No.
Now, at any point in time, did you ever look at anything related to Mr. O'Keefe's head injury?
Oh, yes.
So you reviewed reports in relation to that, correct?
Yes.
Do you have any opinions as it pertains to that?
I would rather defer to the pathologist and neuropathologist on that.
The report thing, I think that's a little weird. That she should have got, I guess she didn't really have.
So who contacted you about this case?
I contacted a district attorney that I had worked with in the past. We were discussing a different case, a case that I autopsied in 1995. And I mentioned that I heard that there was a case in Massachusetts that might have been being handled by one of his colleagues, his former colleagues, and that there was an issue of whether something was a dog bite, and that I might be able to help in that case. to clarify.
And so when you were provided this material, what is it that you were specifically asked to do?
To look at the wounds and the reports and the materials that were sent to me and render an opinion.
And so before you had even been provided any material, before you had even looked at anything, you had already heard information related to there being a dog bite involved in this case, correct?
I had heard that there was a controversy, that there's some certain wounds could have been a dog bite versus perhaps inflicted by a motor vehicle. That's what I had heard.
So what I'm really trying to get at, Doctor, is sort of the timeline. Okay, so you hear about this, when was that?
Sometime just before May 17th.
So sometime just prior to that, you hear about some controversy in a case in Massachusetts involving a dog bite. On May 17th, you get reached out to by who specifically?
His name is John Lewin. He's an attorney in the LA District Attorney's Office.
And then who did you talk to after that?
I reached out to him. I said I might be able to clarify. And then he reached out to Mr. Jackson, I believe, and then Mr. Jackson contacted me.
And not asking specifically anything you spoke about, but at some point the discussion came specifically to dog bites, correct?
He sent me the materials. He asked me my opinion.
Mentioned the materials, asked you your opinion. When did you provide that opinion?
Probably the next day. Yes, I know it was the next day.
So the very next day on May 18th, you provided an opinion?
Yes.
And was that opinion provided in a written fashion, orally? How was that provided?
Orally.
So you reached out to someone shortly before May 17th, spoke to Mr. Jackson on the 17th, received all the material, and then had an opinion by May 18th?
Yes.
But you didn't write any of that down?
No.
Now, beyond the materials that you were provided, what else were you told about the case?
I was told that the victim was a police officer. The decedent is a police officer. I was told that the defendant had been charged, and I was told that that there was a controversy about whether or not these injuries had been caused by a motor vehicle. And I was also told, and I read in the medical record, that the decedent was found outdoors, I believe in the snow, and hypothermic.
Now, in regard to what you reviewed, you didn't review any investigative reports, is that correct?
That is correct.
You didn't review any witness statements, is that correct?
That's correct.
You didn't review any lab reports as far as from the forensic lab or anything like that?
I reviewed the toxicology report.
Beyond that, any other?
If it was part of the autopsy report, I reviewed it.
You reviewed everything attended to the medical examiner's file, is that correct?
Yes.
But nothing from the lab beyond that?
I don't believe I did.
He's getting to the DNA.
Now, this first instance, when you say you heard about it, how did you hear about it?
Well, I believe it was via a headline that I received in my email from the from Boston Globe headline. You know, it was some kind of there was some kind of interesting case, and I got it as an email, and I looked into it.
And when was that?
Well, that was that week in May, just a few days before May 17th.
You subscribed to the Boston Globe online?
I did at that time. I have not renewed it.
How long had you been a subscriber to the Boston Globe?
I'm going to allow it.
7 days.
Probably a year or 6 months, 6 months to a year.
There was never any headlines or anything else that you saw about this prior to that week just before May 17th?
Not that I paid attention to.
I have nothing further.
Anything further, Mr. Jackson?
Nothing further.
All right, so since this is a voir dire, I get to ask questions, doctor? So
yes,
I just have a couple of
Auntie
questions for you. I don't think I
Bev.
really heard you. So could you tell me again what your opinion is and to what degree you hold that opinion?
Yes. These injuries in the arm are, my opinion is that they are the result of animal bites or scratches.
And do you know what kind of animal?
Oh, yes, most likely dog, large dog. And I'm very reasonable, very sure to, what's the word I want? Medical certainty, very
All right,
high,
so
high degree of medical certainty.
Reasonable degree of medical certainty.
Yes, definitely.
Okay, and another question. So I received information that you also viewed all reports associated with Chloe, a dog's prior bite history. Did you review those?
No, I don't recall ever seeing anything like that.
You also reviewed the UC Davis DNA testing results submission forms?
No, I don't recall seeing them.
Okay, any follow-up, any questions based on my questions?
Not for the Commonwealth, no.
No, Your Honor.
All right, you are all set, doctor. I don't know yet whether you'll
That's
be...
tough.
Okay, well, we'll try and let you know. You're going to be around for a few days?
No.
Okay, we'll let you know as soon as we can, okay?
Okay. Okay. All right. Thank you.
She said, no, I would have said, if they paying me, I'll be around. Yeah, put me in a hotel and shit. I'll be around. If they paying me, yeah, sure. Yeah, I'll hang around. I don't know. I might be tough. It might be tough. She didn't take notes. What she has against her, she didn't take notes. She does seem like she has a lot of credentials, though it's from a long time ago. But she does have a lot of credentials, long history. I've seen dog bites.
So I would like to hear argument on this witness before we hear the other witnesses. So, and Ms. Giannetti, I asked you the other day whether she reached out to you or you reached out to her, and you said there was an intermediary. But my concern was whether she came out of nowhere and reached out about this case, and that seems to sort of...
That seems almost like what it is.
Okay. All right. So the question I asked was answered pretty much by this witness, whether she saw something and decided she wanted to come forward.
She saw a headline. What she said? She said she saw a email, and I thought she said did she say she reached out to somebody? She reached out to somebody, the LA or some attorney, and then that person knows this person, or did that person reach out to her? I thought she said she saw a headline.
Motion. What are you asking me to do? Again, I found a violation of Rule 14.
It's gonna be tough.
There are two concerns here: the competence.
There's gonna be riots if you take out this witness. There's gonna be riots.
The witness's testimony, how much she can testify to, whether she should testify at all. What is it you're asking me, Mr.
Natalie, we need you to put in.
Your Honor, I'm asking that the witness be excluded from testifying at the trial for the violation of Rule 14, specifically, I believe it's Rule 14A6. This is a witness, as the court picked up on, that reached out, albeit through an intermediary. With reference to just sort of discovering or coming upon this case in several weeks into the trial. It is concerning given the fact that the witness represented that she had a subscription to the Globe Online, received word of this, and the first time that she had ever seen it or it had grabbed her attention was in that first week of May when, as the court is well aware, there's been widespread media coverage, particularly through the Boston Globe, for years at this point.
Yeah, that's true.
limitations of the testimony, it's also concerning because the disclosure from counsel indicated, again, as the court had noted, I didn't want to get into too much as far as for purposes of this voir dire, but there was additional material that was indicated in the disclosure that the witness had reviewed, including the UC Davis related to the canine DNA or the lack thereof, as well as, forgive me, the dog bite history of that specific dog, which also, I would note for the court, includes photographs of what a dog bite from that specific dog looks like. And that specifically apparently was not provided to this witness, who's then opining on, inferably at least, that that dog was the cause of these particular injuries. However, was not shown specifically anything to do with that bite history as far as by way of reports or photographs. So that juxtaposed or coupled with the immensely late disclosure. I mean, we're talking about at least the 6th week of trial by the time this witness is even mentioned, not on the defendant's witness list, not mentioned at any point in time during the pendency of the case, and then sort of pops up in the middle of May, and to the point that the limited amount of material or information that's provided by counsel as far as disclosure opinion doesn't come until today. So for all those reasons, Your Honor, the Commonwealth is requesting that her testimony in its entirety be excluded from this trial.
Jackson?
Your Honor, exclusion is the highest form of punishment. It's the highest form of sanction that the court has available to it. Just to put a fine point on it, it is a dire remedy. And I know the court has mentioned 2 or 3 times I'm finding a violation of Rule 14. That sounds as if the court is suggesting or has inferred that we did something wrong. We didn't do anything wrong. As the court learned, I didn't reach out to her. She reached out and said, hey, look, I've got some experience with this.
I asked you that the other day, though, and I was told that you reached out to her through an intermediary. I wasn't told she reached out to you through an intermediary.
I don't know that there's a difference. I mean,
what I was trying to get at is this somebody who read about this case and said, you know, I want to be part of that. That's what I was trying to get at. I think it was pretty clear, Mr. Jackson. Go ahead, continue with your argument.
Okay, I did not misrepresent anything to the court.
I didn't say that.
I take offense at the court's tone. Yes, you did say that. You just said that. And I just heard the testimony, and it's not what I said the other day. I know a person in Los Angeles DA's office. I received a text message from that person saying there's someone who reached out to me who said I might be able to elucidate on this controversy concerning the dog bites. I then reached out to her. So when you asked me who reached out to whom, I reached out to her through an intermediary, my friend in the DA's office back in Los Angeles County.
So maybe it wasn't clear what I was looking for. I think it was clear. But go ahead, continue with your argument on this.
My point is, Rule 14 requires a sanction if, in fact, the attorney has done something wrong. In other words, it connotes the idea that we're doing something by actively hiding evidence or holding back evidence or not providing evidence that you know you're going to use at some point in an effort to take a tactical advantage. And the sanction for that is exclusion. I've never met this woman. First time I laid eyes on her was during the process after she flew out here to engage this voir dire process. She indicated I could potentially provide some information about this controversy concerning dog bites. I then sent her materials. I talked to her. I sent her materials. I found her to be incredibly credible. I found her to be experienced. And I found her to be knowledgeable in this very specific area, which is rare. There's not that many people who have published, doctors who have published in the area of dog bites specifically. So I thought it makes sense for me to reach out to her and talk to her, which is exactly what we did. And within a couple of days, literally, you could almost count it by the hours of me receiving her information, we then had a discussion amongst ourselves. Is this somebody that we want to then present on the defense side, on the defense case, and we turned the information over to Mr. Lowry. I understand that it was well into the trial, but that's not a fault of ours, and I don't think the sanction of exclusion is necessary or appropriate to punish Ms. Reed from having an experienced witness testify in rebuttal to ultimately what Dr. Scorti-Bello and the Commonwealth is going to present in their case in chief. That's what she's going to do. She's going to present contrary evidence or an alternative theory of where those injuries came from to a person. Everybody on the Commonwealth side who can elucidate about this has said those injuries come from a taillight, including Mr. Paul yesterday. We have contrary evidence, and Ms. Reed should be entitled to present that evidence, even though it came late. It didn't come late by any fault of ours, and I don't believe that the Commonwealth has made out a prejudice that they can't overcome. It's late. Obviously, Mr. Lally is a skilled lawyer. There's nothing to say that he can't or hasn't been able to prepare for the cross-examination or for an examination in front of the jury. And I just don't think exclusion is appropriate.
All right. So the second part of this argument, and I'll start with the Commonwealth first. So in your motion to exclude, you also raise Daubert-type concerns. So, Mr. Lally, is there portions, if I permit her to testify, are there portions focused specifically on the part of her opinion where she says, I guess the defense expects her to be able to say she will testify that these injuries are inconsistent with having been struck by a vehicle, road rash, or scratches from broken glass or taillight material. I think you have an uphill battle on that part, Mr. Jackson. The Commonwealth, what are you saying? If she testifies, what should she be able to testify to? And don't just say nothing. I want some input.
No. If the court were permitted to test the doctor to testify, Your Honor, what I would submit would be permissible testimony from a legal standpoint. I have some factual questions in regard to that, but from a legal standpoint, I think the court could permit her to testify as to the injuries that she observed, her work and history in that area, observing prior injuries related to animal attacks and whatever consistency she believes that they have with that. I do not think it would be proper to allow this witness to testify or opine anything about the inconsistency with regard to pedestrian injuries. I don't think any proper foundation has been laid for there, whether it be through experiential knowledge in relation to that, or any sort of specialized training or knowledge or anything to do with that. Anything from a forensic pathology or anatomical pathology perspective, I think should also be out of bounds and excluded with regard to this witness. She's certainly a very experienced emergency room physician. So anything in relation to that, I think it's permissible, but as far as the experience when it comes to motor vehicle crashes or pedestrian crashes, of which the court is well aware, there are a litany of different types of interactions a pedestrian can have with a motor vehicle in a collision sequence, and simply saying, well, there was no injuries to the leg, so it couldn't have been a motor vehicle collision is just plain wrong, and not backed up by science or anything else that this witness can testify to from the very limited experience she has in that realm. So if the witness were able or permitted by the court to testify, I would submit that her testimony should be relegated to simply what, if any, opinions, her experience, obviously, and then what, if any, opinions she draws with regard to the causation of the injuries on the right arm, as it pertains to consistency there. But I venture to guess that it's likely that those are probably also going to be, in her opinion, consistent with many other causes beyond that, if she's being reasonable.
All right, Mr. Jackson.
I'll submit, Your Honor. I have no issue with, I just said I'll submit, I'm not submitting. I have no issue with limiting her testimony to the animal attack issue, the dog attack issue. I didn't, as the court noted, I didn't spend any time. I think I may have asked one question that's consistent with the motor vehicle incident. I have no problem if the court wants to limit her testimony to the dog bite aspect and not the motor vehicle aspect. I wasn't planning on going into that aspect anyway, because because I've got another pathologist who's going to do exactly that.
But you did go through it with her, and it's on your disclosure.
It is, but I have no problem editing.
So why is it on the disclosure or where the Commonwealth turned over that she viewed all reports associated with Chloe's bite history in the UC Davis DNA testing? Why is that in there?
Because we sent that in a Dropbox. We sent everything in a Dropbox, and I assumed that she reviewed it. She must not have seen it or opened it.
How should she not have looked at it?
I didn't know.
That made no sense.
But that's what was sent to her. Everything that's in the disclosure is what was sent to her.
Right. If she's permitted to testify, you led her through quite a bit today. You won't be able to. I mean, she struggled with to what degree of certainty she held an opinion. She struggled to what she viewed. She didn't write a report. I have to consider all of these things too, as the gatekeeper as to whether she can actually assist the jury. So I'm not deciding this right here.
Okay,
Mr. Lally, if I do permit her to testify, I will give you time to absorb this testimony and to find an expert in rebuttal for this. How long might something like that take?
Not terribly long, Your Honor. As
we got to fly the lady back out.
As far as preparation, I can't give an exact time frame on that. As far as a rebuttal witness, I'd say a week at the most.
A week from today?
Yes.
Why don't you start looking at least? All right, well, I decide I won't know until Thursday.
Sure.
All right. All right, anything else on this witness?
Submitted, Your Honor.
Okay. All right, next witness, please.
All right.
With regard to
50-50, of course.
And Dr. Renchler, this is a different scenario, and I'm presuming that the court is asking for a year on their qualifications.
Well, I want to know who did what. I want to know, they say we. I want to know who did what.
So is the court suggesting that I go through their entire testimony of exactly what they did, their testing, their opinions, conclusions, the bases of their opinions, conclusions?
However you want to do it, Mr. Jackson, we're here today on the Commonwealth's motion.
I realize that, but it's not the Commonwealth's motion to depose our experts. The Commonwealth's motion is they're not qualified as accident reconstructionists. I don't need to go, and I'm not inclined to give them a free bite at the apple to cross-examine these witnesses twice on the basis of their opinion. I will go through, I think, to the court's satisfaction. I don't think it's going to take long to figure out that they're extraordinarily qualified to render opinions, but I don't think it's incumbent upon me to walk through their entire testimony and give the Commonwealth a free bite at the apple like it's a deposition.
Whatever you want to do. I'm not telling you what to do. Whatever you want to do.
I think the biggest thing to contest today was the dog bites. These people that he has coming up now, the reconstruction stuff. Like I don't think he should have to go through the full entire testimony. I mean, if they're actually really qualified, let them go through the qualifications. Maybe they can try to actually go verify. I'm sure they have probably already. Go verify the qualifications. Sometimes in this trial, it's a battle of the experts, and they disagree. I mean, you find doctors that disagree on shit. You know, one doctor might tell you you're fine, the other doctor tell you got cancer.
So, Mr. you ever see the court the case now here and should truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Thank you.
Just very loudly into the microphone.
He said deposition. That was kind of funny. It's like, it almost is like a deposition, I
guess. Whenever you're ready, Mr. Jackson.
Thank you, Your Honor. Sir, could you please state your name and spell your last name for the record?
Daniel Wolfe, last name spelled W-O-L-F-E.
So what do you do for a living?
I am the director of accident reconstruction at a company known as ARCA, A-R-C-C-A.
And tell us a little bit about ARCA. If you could explain to the court what ARCA is and what its primary mission is.
So ARCA is a forensic consulting engineering company. We have a variety of disciplines that include biomechanics, failure analysis, human factors, premise liability, crashworthiness, and accident reconstruction.
You said that you were the current director of accident reconstruction, correct?
That is correct.
Is that a specialty of ARCA specifically?
Yes, sir.
And what sort of contracts does ARCA routinely engage in?
We typically work for law firms, insurance carriers.
What about other clientele? For instance, maybe it's an insurance carrier or a law firm, but what about the ultimate client, the military, Department of Defense? Have you contracted with other entities or agencies, sporting agencies?
Certainly, yes. We've done research for the military. We do player safety for the NHL. So yes, we are involved in a number of research projects as well.
And in terms of ARCA and its commissions and consultation, is it known both nationally and internationally? Is it recognized as a leader in the area of accident reconstruction?
Yes.
As the director of accident reconstruction, do you specialize in not only accident reconstruction, but human factors as well?
Yes, sir.
Can you give me a synopsis of the professional discipline of accident reconstruction? What is accident reconstruction?
Well, I think that's a very broad topic. I look at the cases that come across my desk. You know, I've been involved with pedestrian impacts, and that could be pedestrians hitting the side of vehicles, fronts, backs, getting run over by vehicles, being struck by a vehicle, then projected into another vehicle. I've dealt with your simple fender bender collisions. I've dealt with collisions that involve 60-car pileups on a highway. So again, accident reconstruction in terms of the scope for a case, it can really vary case to case depending on the facts and circumstances of that case.
And when you say dealt with, are you talking about literally going into, from an engineering and a scientific standpoint, trying to reconstruct what happened, what the causal effects were of that accident, and what the results were, the resultant damage or injuries were?
Absolutely.
What about human factors? What does that discipline entail? What is human factors?
Well, to give you an example of that, so I do a lot of nighttime visibility work where, for instance, let's say a pedestrian's coming out onto the roadway at night. Maybe it's not a lit roadway and you're relying on your vehicle headlights to illuminate that pedestrian. So it's determining when would a driver recognize that individual on the roadway based upon the headlights, if there is any artificial lighting, their clothing. And then we look at how do drivers respond based upon that scenario that they're presented with. So we know that response times are different depending on the hazard that's presented to them. So if it's a pedestrian coming to the roadway, it's a vehicle stopping in front of you. So that's the application of human factors.
And that might include everything from passenger vehicles, commercial vehicles, bicycle issues, motorcycle issues, things of that nature.
Yes, sir.
Okay. What education, training, and background qualifies you to perform the duties that you just described as director of accident reconstruction at ARCA?
In terms of my educational background, I received a Bachelor of Science in Engineering from James Madison University back
He's already up on the prosecution
in 2012, along with a minor in mathematics. Some of my coursework while at James Madison included courses in physics, statics, dynamics, kinematics, material science, and your typical engineering sciences. Subsequent to my undergraduate degree, I then went on to the University of Delaware to pursue my PhD in electrical and computer engineering with a concentration in electromagnetics and photonics.
Did your research area also include physics, in addition to electromagnetics?
Yes, sir.
Optics?
Yes, sir.
Photonics?
Yes, sir.
And lighting?
Correct.
Are you accredited as a traffic accident reconstructionist?
Yes, sir.
By whom?
By an organization known as ACTAR, which is the Accreditation Commission for Traffic Accident Reconstructionists.
Are you trained in photogrammetry to determine vehicle crash and map scene evidence from photographs?
Yes, sir.
In other words, looking at a photograph rather than being at the scene, that is a specialty or a specific area of training that you've engaged, correct?
Yes, sir.
Are you trained in Bosch crash data retrieval analysis?
Yes, sir.
Otherwise known as CDR analysis, right?
Correct.
In terms of professional associations and accreditations, are you certified by the Society of Automotive Engineers?
Yes, I'm a member of that organization.
What about being a member of Optical Society of America?
Yes, sir.
Illuminating Engineering Society?
Yes, sir.
And finally, the National Association of Professional Accident Reconstruction Specialists?
Yes, sir.
You're accredited by all of those organizations, is that right?
I'm a member of all of those, yes, sir.
Have you authored peer-reviewed articles in the area that we've just discussed?
I've authored a number of papers in the field of physics, and one of my most recent publications was that dealing with Toyota and Lexus vehicle control history records.
In 2021, did you author or co-author a peer-reviewed article known as Collision, the International Compendium for Crash Research dealing with vehicle control history and braking issues?
Yes, sir.
Have you qualified in other courts to testify as an expert in the area of accident reconstruction?
Yes, sir.
Importantly, were you hired by the defense in this case?
No, sir.
Before this morning, when you walked into court, have you and I ever met face to face?
No, sir.
In terms of the commission that you were asked
who's he hired by?
to undertake in this case, that have anything to do with the defense?
No, sir.
That have anything to do with the Commonwealth?
No, sir.
So a third-party agency hired you and commissioned you, or ARCA, with the responsibility of doing an accident reconstruction in this case, correct?
Correct.
The person to my left, the female to my left sitting here, you ever seen her before?
Nope.
Do you know who she is?
Yes.
I'm surprised.
How many times have you been qualified in other courts to testify as an expert in the area of accident reconstruction?
I think it's around 20 times to date.
In both federal and state court?
Just state court.
Multiple states?
Yes, sir.
Your analysis, conclusions, and opinions are completely independent, whatever they are. Those analysis, conclusions, and opinions in this case are completely independent of the defense and of the Commonwealth. Have I got that right?
It's based on the evidence. That's correct.
Oh,
and you're not paid by either side here in this courtroom?
Correct.
Wow. I think it's like the first time I ever heard of that shit. I mean, if he was hired by the defense, that's totally normal. Nothing wrong with that. By neither.
You and your team were asked to undertake a review for purposes of accident reconstruction of the case that's now pending before the court. Is that right?
That's correct.
Who at ARCA was assigned to the team who ultimately would undertake that analysis?
So it was myself, Dr. Andrew Renchler, and Scott Klein.
And Scott Klein has a Master of Science, is that right?
I believe he's got a Bachelor of Science in Mechanical Engineering, yes.
In engineering?
Correct.
All right. And Dr. Renchler is a PhD in what area?
Biomechanical Engineering.
All right. Were you provided and did you review certain materials in furtherance of your consultation in this matter?
Yes, sir.
I can have just a moment, Your Honor.
Yes.
Yeah. Oof. Oh my God, smoking. Smoking. It doesn't work for free. It's a third party.
I'd like to use my time efficiently, Doctor. I'm going to read through a number of materials that you reviewed. Before I do that, may I approach, Your Honor?
Yes.
Oh, he got his work cut out for him. Oh, Lord.
I just want you to take a look at the first 2 pages of that document and tell me if you recognize that.
Yes, sir.
What is that? What are those 2 pages?
These are the first 2 pages from the report that ARCA issued in regards to this matter.
Do you see a list of 14 items on those 2 pages?
Yes, sir.
Is that an accurate reflection of the items that you were provided by this other agency to review in terms of coming to your opinions and conclusions concerning this case?
Yes, sir.
May I approach, Your Honor?
Yes.
Those items include the Norfolk SPDU homicide death report, correct?
Correct.
The Commonwealth of Massachusetts Department of State Police crime scene report, correct?
Correct.
The OCME dispatch removal report, correct?
Correct.
Photographs of the incident location.
Correct.
Videos of the incident location.
Correct.
Photographs of the 2021 Lexus LX 570.
Correct.
Photographs of recovered evidence.
Correct.
Crash data retrieval report from the 2021 Lexus 570.
Correct.
Report of autopsy.
Correct.
Autopsy photographs.
Yes.
3-dimensional laser scan data of a Lexus LX 570.
Yes.
A VINLink, VIN capital LINK report sheet for the 2021 Lexus LX 570.
Yes.
Expert AutoStats data sheets for a 2021 Lexus LX 570.
Yes.
And publicly available literature, including but not limited to the documents cited within the report, learned treatises, textbooks, and scientific standards, correct?
Correct.
All of those items and data were reviewed by you and your team in coming to your conclusions and opinions in this case, correct?
Yes, sir.
And I'd like to ask you one other series of questions concerning sort of who did what. Your report indicates that there were, in no small part, two undertakings, if I can ask them in terms of pillars: the damage to the vehicle and the injuries to the body of John O'Keefe. Correct?
I would say that's a fair characterization. Yes.
Okay. And I may be butchering this a bit because I'm not being very scientific, but were you more responsible for the vehicle damage or the injury damage?
The vehicle damage.
And who on your team was more responsible for the injury damage?
That would be Dr. Andrew Renchler.
Obviously, Dr. Wolf, in coming to your opinions and conclusions concerning the damage to the vehicle, you had to consider the damage to the human being, correct, John O'Keefe?
Correct.
And as the team leader, in terms of Dr. Renchler coming to his conclusions and opinions concerning the damage to the human being, he also had to consider the damage to the vehicle and the interplay of the two, correct?
Correct. We work together.
I was just going to say, is that how you two and Mr. Klein work together to come to the opinions and conclusions that are cited in your multi-page report?
Yes, sir.
Thank you. That's all I have, Your Honor.
Okay.
Okay.
Mr. Lally?
Lally.
Thank you, Your Honor.
You can't block this, man. So, I'll wait.
Good morning, sir.
Good morning.
Now, you went through a list of about 14 things that are contained within your report that your firm or your agency was provided with that you reviewed, correct?
That is correct.
Did you specifically review all 14 of those things, or was that done as sort of a team?
Yes, I looked through all of the documents.
So you personally looked at all 14 of those items that are listed within the report?
Yes, sir.
And you indicate that it was your opinions or what you did in this case, that was you were asked to answer specific questions, correct?
Yes.
It wasn't like you were just tasked with, hey, here's some facts, go do or take a look at a crash reconstruction or read a crash reconstruction. You were asked very specific questions and you tried to answer them the best you could, correct?
I don't know that there were specific questions. I think ultimately it was an open-ended question.
But related to you testified as to two specific areas that your firm or your agency looked at, right?
Those are the disciplines that the report covers, yes.
Well, you testified about some other areas of expertise as far as human factors, visibility, luminescence, things like that. You didn't do any of those things here, correct?
Wasn't part of my scope in this case.
And the scope in your case, you indicate that it was based on the evidence, correct?
That is correct.
Now, to be fair, that's based on the evidence that you were provided, correct?
Correct.
So what did Mr. Klein do?
So as a part of the engagement with the entity that ultimately retained us in this, due to the confidentiality of it, only those who had access to the material to the file were allowed to review it and discuss it. And essentially, Scott Klein served as kind of another reconstruction expert to essentially bounce ideas off of and help with the review.
So for lack of a better term, sort of provided, let's say, sort of technical review of your work and Dr. Renchler's work, is that correct?
I would say assist us with the analysis, yes.
Now, obviously, your firm or your agency issued a report in relation to what you did, correct?
That's correct.
And you've obviously had a time to review that report as far as what's contained in there factually, as well as conclusions and opinions, things of that nature?
Yes.
So is it your testimony that anything that has to do with anything factually, conclusions, opinions, or otherwise, in relation to the motor vehicle damage, those are your opinions, those are your conclusions, correct?
I would say that's fair, yes.
And again, based on the evidence that you were provided, correct?
Correct.
And so the facts or evidence or conclusions or opinions related to injuries to Mr. O'Keefe, that was Dr. or Mr. Renchler's area, is that fair to say?
Dr. Renchler, yes.
And again, that was based on the evidence or whatever he was providing, correct?
Correct.
Which would be the same materials that you had testified that you had reviewed, correct?
Correct.
I have nothing.
Anything further, Mr. Jackson? All right, so, Doctor, I just have one question for you. What specifically were you asked to do?
I'm sorry, Your Honor, I didn't hear the court.
What specifically were you asked to do?
So the agency that retained us gave us a selected quantity of file material related to this case, and essentially left it as an open-ended question. Ultimately, was the evidence consistent with a pedestrian interaction between Mr. John O'Keefe and the Lexus?
Okay, you said selected quantity of information. Who selected that information?
As far as I'm concerned, it would be the Department of Justice and the FBI.
All right, and they just gave you what they wanted to give you, as far as you know?
We had no say in what material was handed over to us.
Okay. All right. Thank you very much. Any questions based on my questions?
No, Your Honor.
Mr. Lally?
Just briefly. And I apologize for this. I'm just unaware. Is it Mr. Wolf or Dr. Wolf?
Dr. Wolf is fine.
So, Dr. Wolf, when you say that you were asked specifically whether or not the evidence, the limited scope that you were provided was consistent with a pedestrian collision, were you asked sort of in general terms as far as any type of pedestrian collision, or were you asked specifically as far as biomechanically could say the injury to the back of Mr. O'Keefe's head have been caused by contact with the vehicle? How open-ended was this question?
Again, I think it relates to, is the vehicle damage consistent with the pedestrian impact, and are the injuries consistent with the pedestrian impact?
And again, the whole panoply of injuries, is that correct?
I'm sorry, what was your question?
Let me rephrase. So did anybody specifically ask you to determine whether or not the injuries to the back of Mr. O'Keefe's head could have been caused by a motor vehicle?
I don't know that they asked us specifically. Again, they basically asked us to perform an accident reconstruction and biomechanical analysis and basically tell them our findings, and these are our findings.
And in the materials that you reviewed, did you see anything in there of any sort of statement, suggestion, intimation, anything at all that suggested that the injuries or the fracture to the back of Mr. O'Keefe's head was caused by a motor vehicle?
In terms of direct contact?
Yes.
No, I don't believe so.
Nothing further.
Anything?
Nothing.
All right, Dr. Wolf, you are all set, sir.
Thank you.
Wow. Definitely, he seems more credited and everything than what the prosecution had. He's getting paid. He's not there for free. That's what somebody said. Oh, he's for free because he's just doing this out of the goodness of his heart. No, it's just he's being paid by a third party. He was part of, I forgot what somebody said earlier, the federal investigation into the case. If I have time, I'll read a snippet about it. Or if not, we'll do it after. Okay,
I'm just going to ask you to be mindful of the court and step up. You're going to remain standing.
Well, you sound this way, you have to give the court in case now here. The whole truth and nothing but the truth, so help you God.
I do.
Thank you.
Sit close to the I'd like to go move up and down and speak up loud. Gotcha.
All right, whenever you're ready, Mr. Jackson.
Thank you, Your Honor. Sir, could you please state your name and spell your last name for the record?
Certainly. Dr. Andrew John Renchler, Rentschler.
Sir, what do you do for a living?
I am a biomechanical engineer and accident reconstructionist.
In what area of the country do you live in?
I live in Pittsburgh, Pennsylvania.
What is your title currently at your company?
I am a vice president and director of Biomechanics for the Midwest Division.
And what is the name of that company?
It's called ARCA LLC.
And what is the main mission of ARCA. What does ARCA do?
So ARCA is a engineering consulting company, and we have several different types of engineers, biomechanical engineers such as myself, accident reconstructionists, mechanical engineers who look at crash worthiness, safety of vehicles, and other types of events. So we really do all types of work. We do litigation type work, as well as research and development for government and private entities as well.
Let me have just a moment, Your Honor.
Yes.
Can you give me a brief synopsis of the professional discipline of injury causation biomechanics? What is that?
So injury causation biomechanics is really applying traditional engineering principles to the human body. So as a biomechanical engineer, I look at the response of the body to accelerations and forces and determine how an injury occurs. You know, an injury to the human body is just an engineering problem. For instance, a mechanical engineer might look at a piece of steel and you know the size of the steel and the shape of it. And if you apply a force in a certain direction, that steel will bend and eventually break. Well, we do the same thing, but we look at the human body. How much force do you have to apply, and how does that force have to be applied in what direction or manner to get a specific injury, whether it's a skull fracture, an intervertebral disc injury, a concussion. So we look at the response of the human body to different forces and accelerations in different types of settings. And ultimately, our hope is to help mitigate or prevent injuries, whether it's in a motor vehicle accident, sports setting, industrial setting, auto pedestrian impact, try and make products and environments safer for individuals.
And that's different from what medical doctors, correct?
It is, yes, sir.
Little boy walks into an ER with a broken arm. The medical doctor wants to reset the arm and fix the arm, correct?
That's right, yes.
What does a biomechanical engineer want to learn about the broken arm?
We want to learn how that break or that fracture occurs. I always say that we kind of approach injuries from two different directions. You have an injury occur. After it occurs, moving forward, that's when the medical doctors get involved. They diagnose the injury, determine the best way to treat it, what's the prognosis. As a biomechanical engineer, I kind of take the reverse direction. We look at, here's the injury, here's what's diagnosed. Well, how did that injury occur? You know, how much force do you have to apply to cause that fracture? How did the bone have to be loaded? How did it bend to actually cause a specific type of fracture? So we really kind of approach the injury from two different directions.
Understood. And given that scientific approach, oftentimes you can come to conclusions and opinions, scientific conclusions and opinions about the causation of an injury, correct?
Absolutely. Yeah. And I mean, ultimately, that's what biomechanical engineering is how does an injury occur? Why did it occur? And what type of setting did the injury actually occur? What type of loading and what type of kinematics do you need to have this injury actually occur?
Can you tell the court a brief synopsis on the discipline of human factors? What part does that play in what you do for a living?
Well, human factors is a large part of it as well. I mean, from a biomechanical standpoint, we look at the body. We have to know anatomy. We have to know the makeup of the body. And then human factors plays a part of it as well, as how individuals respond or what their response is to different types of environments or reactions. It really all plays into looking at a specific event. How did someone react? How did their body move? How was the body loaded? There's all different types of factors that you have to apply. The human factors, kinematics, kinetics, biomechanical, musculoskeletal interactions. It's all these different factors that are really involved in performing an analysis to ultimately look at injury causation.
Doctor, as the Director of Biomechanics and Human Factors at ARCA, what education, training, and background qualifies you to perform those duties?
Well, I got my Bachelor's of Science in Mechanical Engineering with a minor in Biomedical Engineering from Carnegie Mellon University in 1995. I then went on to get my Master's in Bioengineering and Biomechanics from the University of Pittsburgh in 2002. And then I got my PhD or my doctorate in bioengineering and biomechanics from the University of Pittsburgh in 2004.
Can you give us a brief work history up to and before ARCA?
Sure. So I got my PhD in 2004, and then since then I've worked in the consulting field for biomechanics. I've worked for a company out in Davis, California for a while called Biomechanical Engineering Accident Reconstruction. I then joined another engineering company in Jacksonville, Florida for about 3 years called Chesapeake Engineering and Design. And I have now been with ARCA for approximately 16 and a half years.
And in those positions and in your position currently as a director at ARCA, do you specialize in research and analysis attendant to evaluating and studying the relationships between crash injuries, crash forces, human kinematics, and human tolerances?
I do. I mean, that's really what I do on a daily basis, whether it be in litigation type cases or the research and development we do for different companies or entities, or even internal research that we perform at ARCA.
Doctor, what professional associations and accreditations do you have?
I'm a member of the American Society for Mechanical Engineers, as well as the Society for Automotive Engineering. Now, with respect to biomechanical engineering, there's no actual professional licensure for biomechanical engineering. So a PhD or a doctorate is the highest degree you can have in that field.
Are you also a reviewer for archives, physical medicine and rehabilitation, and biomechanical engineering online?
I am, yes. Usually if you publish articles in a journal, usually that journal comes back to you and asks you to be a reviewer. So I certainly do that type of work as well.
I'd like to ask you a couple of questions about your ongoing education, your professional education after your PhD. Have you continued your education in areas of biomechanics and high-impact injuries from the NTSB?
I have. I've taken classes through the NTSB and SAE, the IPTM, Police Technology Management Training Center. There's several different entities I've taken biomechanical and accident reconstruction courses through.
So the alphabet soup, if you will, of biomechanical engineering and human factors.
Right, yes.
And you continue that today?
I do, yes, sir.
Any specific training in human kinematics?
Yes, I do have training in human kinematics.
Just out of curiosity, how do you define what is kinematics?
So kinematics is the motion of the human body and looking at how the body moves. And it's irrelevant or irrespective of the forces that cause that motion. So we're really looking at, for instance, how one body part moves with respect to the next. We can see how the body moves as a result of a specific type of event.
You mentioned injury mechanics previously in one of your answers. What is injury mechanics, and how does that relate to biomechanics?
So again, that's a subset of biomechanics, looking at the response and the strength of the different parts of tissue of the human body. On a very basic level, to get an injury or have an injury occur, you need really two factors. You need enough force to cause injury to the tissue, and you need that force applied in the right manner. So if I wanted to fracture my elbow, I certainly couldn't take a hit on my shoulder and expect my elbow to fracture. Its force is exerted in the wrong location. And likewise, if I just lean my elbow on the counter here, that's not enough force. So you need the force and you need the application of that force in the correct manner to produce what we call an injury mechanism.
And have you ever participated in any studies or research in this area? In addition to your dissertation, getting your PhD, what about additional studies and research in this general area?
I have, yes, sir.
Can you describe that for us briefly?
Certainly. Well, just at ARCA, I've worked with the United States military. We worked on the design of the MRAC vehicles, the mine-resistant ambush-protected vehicles over in Iraq and Afghanistan.
That's a troop carrier, correct?
That's correct, yes. And the issue there is they go over the IED, the improvised explosive device, and it blows the vehicle up off the ground. So you're getting very large forces and accelerations through the vehicle, through the seat, into the soldier's spines. So we're seeing very traumatic and severe spinal and head injuries. So at ARCA, we work on what we call an energy absorbing seat design. So when the vehicle gets blown off the ground, that seat is designed to absorb the force and the energy to protect the soldier's spine and their head.
Did you take part in the design of that seat?
I did, yes, sir.
Has that been employed by the Department of Defense?
Yes, it has been.
And are troops utilizing that new seat design, that safe seat design in that troop carrier to this day?
As far as I know, it's from what they'll tell us, yes, sir.
Understood. Are you also published in this field, Doctor?
I am, yes.
Can you give us a couple of examples of current studies that you're involved in or publications that you've done in the recent past concerning bioengineering and the impact or the association that it has with human factors?
Sure. I mean, and another project I'm working on is we work with the NHL actually at ARCA. We have an ongoing, relationship with the Department of Player Safety. For instance, we helped redesign part of the rink. In every arena, they had at the end of the player area, there was basically a 90-degree stanchion where the glass met. And so players were kind of getting checked down in the boards and then hitting up against the glass. And actually, somewhat ironically, it was Chara hitting Pacioretty into the glass, the Boston-Montreal game, and caused a cervical fracture and concussion. And the NHL came to us to see if we could have a redesign of the rink to make it a little safer. So we took crash test dummies, the anthropomorphic test device, which you've probably seen on TV. The automotive manufacturers use them all the time, and threw them into different configurations of glass. And now in every arena in the NHL, it is basically a curved piece of spring-loaded Lexan or plexiglass, where the players now, they hit into it, it absorbs the impact, and they glance off of the glass.
Is that a design that you helped come up with?
It is, yes.
So both from the United States military as well as professional sporting leagues, they've come to you to help save lives, lower risk.
That's right, mitigate and prevent injuries, yes, sir.
What about crash and sled testing?
Yeah, I've performed a number of crash and sled tests. When you look at any vehicle that's driven in the United States, it has to pass federal motor vehicle safety standards. There's federal regulations that they have to pass. And, part of that involves running the vehicle into a wall at 35 miles an hour, hitting it from behind, rollover type impacts. And they have these crash test dummies in those vehicles. So we perform a lot of testing for different cases and situations where we put that dummy in the vehicle and we evaluate the safety system, whether it's the lap and shoulder belt, or if it's the airbag or the seatbelt pretensioner, determine how to make the car safer. And part of that is looking at the force that's exerted on that dummy, because there's tolerance values. We know how much force it takes to cause specific injuries. So we want to make sure in certain instances, at certain speeds or impacts, that if someone's in an accident, the force acting on, say, their head or their neck or their chest is going to be below these established tolerance values.
Speaking of how much force it takes to cause an injury to a human body, have you engaged in any testing or published in the field of auto pedestrian incidents?
Yes, I've been involved in a number of studies where we're looking at auto pedestrian type impacts. Again, a lot of times we'll utilize the crash test dummy where we'll set it up and we'll actually have it struck by different vehicles or different objects to look at the response of the body. It's very important if you're talking about an auto-ped type impact. You have to know the configuration of the pedestrian, the vehicle, where they hit on the vehicle, whether it's a projection type impact, a wrap, a fender vault. It really all depends on how the person's positioned and the amount of force and speed involved in that type of an impact.
And staying with that for a second, that basic subject matter, have you also engaged in studies related to slips and falls where somebody might fall from a standing position and injure themselves either to their head, shoulders, whatever, and those kinds of injury impacts?
I have, yes. And then one of the issues we look at it there is a lot of people fall, especially elderly people. So we want to look at what types of forces are being produced. You look at hip fractures, if you slip and fall backwards, head fractures. So we're trying to determine how to prevent those falls from happening and also create devices or products that can help actually prevent injuries if someone does take a fall.
Doctor, have you been retained as an expert in the area of biomechanical engineering and human factors in the past?
I have, yes, sir.
May I approach, Your Honor?
Yes.
Can you take a look at that document and tell me if you recognize it?
This is a list of my deposition and trial testimony.
Your Honor, I provided that to the court this morning.
Yes, I appreciate it. I had a chance to look at it.
Okay. That's about I don't want to go through everything. That's about a 14-page document. Is that correct?
That's correct, yes, sir.
Let me just ask it this way. How many times do you think you've been qualified as an expert in the field or testified as an expert in the field of biomechanics, biomechanical engineering, and human factors?
I've testified probably over 150 times in numerous state, federal, civil, and criminal courts throughout the country.
Your Honor, move to, I'm sorry, may I approach?
Yes.
For the purposes of voir dire, Your Honor, I would ask that this document be marked.
Sure.
Renchler voir dire. Thank you. Have you ever testified in criminal court as an expert in biomechanical engineering?
I have, yes.
How recently have you testified in criminal court?
Well, actually, I've testified twice. The end of May, I think May 31st, I testified in McKean County, Pennsylvania. For the prosecution, it was a case where the defendant was accused of beating his girlfriend to death and basically said that she fell down the steps. So my testimony involved determining how her injuries occurred and that they were entirely inconsistent with what would have happened during a stair fall.
What about another case?
And then about a week after that, around June 6th or 7th, I testified in Cambria County, Pennsylvania, again for the prosecution for another homicide case where the defendant was accused of essentially beating his wife to death and then said that she actually fell backwards and struck her head, caused a skull fracture on the side of the sink. So my testimony, again, pertained to looking at the injury mechanisms and determining that his story of her falling back and striking her head on the sink, it's inconsistent with the injuries and the type of force that would have been exerted in that case.
In both of those murder cases, you were hired or retained by the prosecution in the case, not by the defense, correct?
That's correct, yes, sir.
You gave your opinions in furtherance of the prosecution's case in chief, not the defense case in chief, correct?
That's correct, yes.
With regard to this case, you were asked to look at several items. We've already gone over those in the other testimony, so I won't belabor that. You were asked to look at several items, correct?
I was, yes.
And ultimately, based on that series of information, that universe of information that you were provided, see if you could come to an opinion and conclusion concerning the incident before the court now, correct?
That's right. See if I could determine what happened, how the injuries occurred, and the events leading up to and during that process.
Without going into your conclusions and opinions, were you able to come to conclusions and opinions to a reasonable degree of science and certainty?
I was, yes, sir.
You were not hired by the defense, by me, or anybody on the defense side in this case, correct?
That's correct. I was not.
You were not consulted with or hired by the Commonwealth either?
That's correct. I was not.
It was a completely independent agency, is that right?
That is correct, yes, sir.
Before this morning, have you and I ever met?
No, sir.
And you and I have never talked about the substance of your opinion and conclusion, correct?
We have not. That's correct.
You did reduce those opinions and conclusions in conjunction with your team to a report, is that right?
I did, yes, sir.
And your understanding is that report was made available both to the defense and the Commonwealth in this case, is that right?
Yes, sir. That's correct.
I have nothing further to ask.
Okay, Mr. Lally.
Thank you, Your Honor.
Lally.
Good guess.
Just a few questions for you, sir. Good afternoon.
Good afternoon, sir.
Now, with relation to your work in this instance, in this case, were there any limitations as far as confidentiality or anything that were put on you or any of your team?
What do you mean by confidentiality?
As far as who, what, where, and how you could discuss what you did?
Well, yeah, I mean, certainly we just discussed with who we were retained by in this case. I don't believe I discussed the case with anybody else except for my cohorts who were also involved in the case.
And so my question, sir, more is geared towards, at some point you were made aware that your report and your findings were made available to both the prosecution and the defense in this case, correct?
I was made aware of that, yes, sir.
And when you were made aware of that, was there any limitations on given to you as far as who you could discuss your report, your findings, or anything with?
Yeah, basically given the direction or the request that I don't actually discuss the substance of my opinions or my report with anybody aside from who we were originally retained to work for.
Now, may I approach, Your Honor?
Yes.
Sir, I am going to show you the first couple pages of your report, specifically right down the bottom. There's a list of items 1 through 14. I ask you to just review those.
Voir dire. Jamcracker, thank you so much for the did I say 18 months? 18 months. Amazing.
Now,
I'll read your message in a second.
Totality of information that you and your firm were provided with in reference to what you did in this case?
I believe it was, yes, sir.
So nothing beyond that list of 14 things did you have occasion to look at, review, or have any opportunity to see at any time?
Well, aside from we did do testing in this case, so we did do other
Aside
work.
from your independent testing, I'm asking as far as material provided by whoever employed you, that is a sum and total of what you received, correct?
I believe that would be correct, yes, sir.
And did you personally review each of those 14 items? And I don't fault you or your company for this, but within the report, there's a lot of we. So what I'm asking is, did you personally review each of those 14 items that are listed in that report?
I did personally review every bit and every page of information that was provided in this case, yes, sir.
And to be clear, just to sort of close the loop on this, when it comes to those 14 items, were you allowed to ask for any additional items, or was it just you were limited to this is what you have, go form an opinion?
There may have been discussion about if there's other information available, but I believe ultimately that we rendered our opinions obviously just on this specific information that was provided to us.
Now, as far as your opinion in your report, when was that issued?
February 12th of 2024.
So that date on the top of the report of February 12th, 2024, that's when you sent the report to the people that contracted you to do the analysis in the first place?
That's correct, yes, sir.
May I approach you?
Yes.
Thank you.
Sure.
Not much.
Now, am I correct? And what I'm trying to ascertain here, Doctor, is just sort of the different roles that you and the other members of your team performed in reference to this. Am I correct in that your primary role in this pertained to the sort of biomechanical engineering analysis of injuries sustained by Mr. O'Keefe?
That would be correct, yes, sir.
And not to put too fine a point on it, but Dr. Wolf would have been more responsible for issues related to the vehicle itself.
Generally speaking, yes, that would be correct.
Obviously, there's some interaction between damage to the vehicle and injuries to Mr. O'Keefe, but as far as your primary sort of any opinions contained within this report pertaining to injuries to Mr. O'Keefe, those would be your opinions, correct?
Yes, any opinions or information with respect to the injuries would be my purview and my opinions in this matter, yes, sir.
And concomitantly, so any opinions related to damage to the motor vehicle, those would be opinions of Dr. Wolf, is that right?
Well, to some extent. I mean, certainly I would have opinions as well based on the interaction or alleged interaction between the body and, for instance, the vehicle in this case, and what damage to both the body as well as the vehicle you would expect. So I think there's basically some overlap between those issues. I wouldn't say that it's a complete separation.
And so, and again, Doctor, what your opinions or ultimate conclusions are, whether they be yours or Dr. Wolf's or a combination of the two, it's all limited based on the information and the evidence that you received, correct?
It certainly is based on the information that we reviewed and listed in our report. Yes, sir.
Now, as far as for the mandate or from the agency that hired you, were you asked to answer a specific question, or were you asked to just do an analysis based on what we sent you, or how was that put to you as far as what you were doing?
There was a specific request that we were asked to perform and to evaluate in this case.
And specifically what I'm asking, sir, is there's an analysis in there of whether or not the injuries to the back of Mr. O'Keefe's head could have been caused from contact with the vehicle, correct?
That is part of my analysis and opinions, yes, sir.
And were you specifically asked to address or answer that question by the agency that hired you?
That was one of the questions I was specifically asked, yes, sir.
I have nothing further.
Anything further, Mr. Jackson?
Thank you.
All right, so Doctor, I have a couple of questions for you, sir. So regarding the specific request, what were you tasked to do specifically?
So specifically overall, I was tasked from the biomechanical standpoint to determine or see if it's possible to determine how the injuries in this case occurred. And part of that was determine whether
It'll be hard for me not to look at this lady that's like staring at me.
The injuries, the head injury and the arm injuries resulted from contact with the Lexus in this case.
Okay. And regarding all of your prior testimony, a good deal of it seems to be in depositions. Any of those in Massachusetts?
There's a couple, I believe. I've testified at trial in Massachusetts,
Okay.
Middlesex Superior Court.
Do you know where that might be? I do want to look at that.
I can find it for you, maybe a couple of months ago.
Was it in a criminal case or a civil case?
Oh, it was in civil case.
Okay.
I think, let's see here. I think, yeah. So let's see. There was one November 14th, 15th, 2023, Middlesex Superior Court. That was probably the most recent one.
Hey, what number is that on there if I want to go back and look at it?
That is number 310.
Thank you. Is there another Massachusetts case?
Oh, I'm sure there are because I know there's some from earlier in my career. Let me see.
This
See
is
if I
normal
can find
too.
for you real
She's
quickly
doing.
here.
Judges, they'll ask a couple of questions too during the voir dire, whatever.
Read this. Connecticut. Ellsworth, Louisiana.
So, these two witnesses, I guess they're They're not going to go. I mean, they benefit obviously.
So
the defense, I
there's
guess.
68. I'm gonna butcher
conclusions did
Worcester.
they come
Worcester.
Is that a civil or criminal case, Doctor?
That is a civil case as well.
Okay. What year was that?
Oh, that one was 2012.
Okay. Any others that you think of or you see?
There may have been a couple others. I don't recall off the top.
All right, I'll go through it more closely. I
Sure.
appreciate you saving me some time.
Absolutely.
All right, any questions based on my questions?
No, thank you, Your Honor.
No. All right, you are all set, sir. Thank you very much.
Thank you, Your Honor.
I wonder if they're going to call it a early day. That was all the witnesses, I think. I want to read something for you guys too on Twitter. There's no way these two guys don't testify. I don't think so, you know. But the that doctor, I wonder, Dr. Marie Russell. I'm going to read you a tweet from his attorney.
All right, so Mr. Lally, I will hear you on your motion. Now, we didn't get into the ultimate opinions and the basis for that opinion, but I'll hear you on your motion.
Your Honor, essentially what Commonwealth was seeking and had been seeking was just in reference to that, as far as who did what and who was responsible for what and what were the items reviewed, and is that the totality of it? There's a date on the report. I don't know if that was a date as far as when it was filed, when it was opinion was rendered, when that was provided, what was provided to them in the course of their analysis. So I think very simply what the Commonwealth had been seeking for the most part was covered today.
Okay. All right. I have some questions as to the scope of the testimony of the witnesses.
Hey, Carolyn.
So, Mr. Jackson, you intend to have them testify consistently with the report, everything covered in the report?
Correct.
And the conclusions, all 4 conclusions in the report?
Correct.
All right, Mr. Lally, what's your take on this?
I do have an issue with number 4. I don't think they're qualified to testify to. I don't think either of them is qualified to testify to that. That's more of an area of forensic pathology.
What do you say to that, Mr. Jackson?
Number 4 is, their opinion is, there is currently insufficient evidence to determine the cause of Mr. O'Keefe's skull and brain injuries or the circumstances surrounding the event. That is well within the scope of their expertise. Obviously, I don't think I have to beat this dead horse. They are highly, highly qualified to render all four opinions. And if the evidence, in their opinion, their expert opinion, to a reasonable degree of scientific certainty, which is what's evidenced here by the report, is that there is insufficient evidence to determine the cause of Mr. O'Keefe's injuries, then that is an opinion that they are well within it's well within the scope of what they can testify to. That's their opinion, that's their conclusion. Mr. Lally is going to have an expert, Trooper Paul, who's going to differ, or who has differed in that opinion. So be it.
And I would have kept it out. Remember, I would have kept out any medical part had there been an objection. And when you objected, I sustained the objection.
I think we're talking about two different things, apples and oranges. I didn't, that's not, Trooper Paul's opinion is that his injury or his injuries, or I think he said variously that it was blunt force, could have come from the curb, or it was blunt force because the road was blunt. That was his opinion, and he was sticking to it. This is contrary to that. Both of these individuals have come to the conclusion and opinion that the evidence is insufficient to support that determination, and it's well within their purview to testify to that.
Your Honor, if I may, I don't think that's her actual opinion. I initially didn't think of it in these terms as it's phrased on the cover page of the report. If you look at the actual opinion
I was
and findings,
looking at the last page. Are they the same on the front and the back?
I think the front is a little more definitive and concerning. The back, I think, more as to it's consistent with a whole multitude of different things. So the fact that I don't really think that's an opinion at all, to be honest with you.
All right, I'll take a look at this more closely, give you a decision Thursday. All right, I did not expect it to go this quickly. We could have had the jury here, but I'm sure you all could use the afternoon to prepare. All right, Mr. Lally, let me know Thursday if you need. Are you ready to go forward at least with your case on Thursday?
Oh, yeah, sure.
Let me know Thursday if you need additional time. If I let Dr. Russell testify, how that impacts our schedule.
Absolutely.
Okay? All right, but I don't want that to be a concern of yours, how it impacts the schedule. That's my concern. I just need to know. All right, so anything else?
For the Commonwealth.
I think that's it. Thank you.
Okay, we'll see you Thursday morning.
Court, all rise.
All right, so let me show you. Oh, damn it. I think I closed it. No. Damn it. Oh, there it is.
Hey there, Karen.
Hi, it's Law and Crime. So I don't know if they're going to let the doctor in. I don't know. But this lawyer thinks that ultimately the judge. I do not believe that the judge will ultimately let Dr. Marie Russell testify. The testimony would go against a potential third-party culprit defense. As we speak, the defense has not laid a proper foundation allowing her to testify, but merely confuse the jury. And then somebody here counters and says the defense has not had an opportunity to present its case. The key officer revealed his intent in his text to construct a case that punished the defendant. Her testimony does more than support a third-party defense. It challenges the testimony of the state experts. And he replies back, the judge's ruling on third-party culprit was that the defense needed to lay the proper foundation through the Commonwealth's witnesses. They have not, according to this person, irrelevant. Her testimony will be excluded because it would go directly towards the defense the judge would specifically exclude. So I don't know. They're saying the defense has not laid the third-party culprit. Let me show you this document too. I'm sure people have seen this. I am really curious to see what these reconstruction guys are going to testify. They seem highly knowledgeable, experienced. So I'm very curious to see. Maybe they'll show us video. I don't know, and hear their opinions. But excuse me. On February 21st, 2024, the U.S. Attorney's Office produced to the Commonwealth and defendant a substantial number of confidential documents from its investigation. On March 8th, 2024 and March 19th, 2024, the U.S. Attorney's Office confirmed to the Commonwealth and Defense that all information relevant and material to the pending Norfolk Superior Court criminal proceeding against Karen Read had been produced. On March 19, 2024, the defense indicated it was satisfied with the U.S. Attorney's Office representation that it had received all the relevant material information. In sum, the federal documents are consistent with the Commonwealth theory of the case and debunk the defendant's allegations of a cover-up or third-party culprit. Throughout the course of the federal investigation, the defense communicated with the U.S. Attorney's Office and provided material and records that advanced the defendant's theory of the case. The unusual collaboration resulted in discovery that far exceeds bounds permitted by the Massachusetts Rules of Criminal Procedure. So I guess they had to try to prove their third-party culprit. Now, some people, they feel that they did. Some people say that they proved it or whatever. Young Thug, I don't know if that doctor's gonna make it in, and that was a big part of it. But maybe the reconstruction experts are enough to create reasonable doubt. But if you had that doctor in there too combined, woo, maybe, I don't know, what would the jury think? Not if she was introduced wrong, which might be the violation. If she's thrown out, it was legal. The thing is, the only thing is, it kind of makes it seem, and I'm still trying to understand, it seems like there was some type of misunderstanding. She said she got that email and that she's been subscribed to the Boston Globe, right? And one of the things the prosecution was trying to argue was like, so how is that the first time, which was like May this year, and she said she was subscribed to them for like a year. The Boston Globe, a local paper, there's no way it's not the first time they've talked about it, but I guess she's claiming it's the first time she knows the email. And so this is the part where I don't understand. I think they're trying to contend this. I thought she said that she reached out to a third party and said, I could probably be a help with this. And that third party reached out to Action Jackson. But then I think Action Jackson said he reached out to the third party and that person just knows this person. But he said he never met her before. I don't know. I might be heard that wrong. Even the judge was kind of confused. I don't know. So they're just, the judge or the prosecutor was kind of worried, like, oh, they should see this and just see this as an opportunity. But what might be interesting, here's what might be interesting. The judge did say that, like, do you think, to the prosecution, can you find an expert witness to rebuttal her? A lot of times this stuff is a battle of the experts. That case that I covered, the case that I was on as a juror back in the day, years and years ago, it was a battle of the experts. And the defense had some good experts. And the guy was charged with DUI, not manslaughter. So he got off decent. It could be worse. That former baseball player. Yeah. Bev said Jackson told her earlier that he reached out, and today he said she reached out. That was the thing. But Jackson snapped. Jackson even snapped at the judge. I was like, oh shit. He's like, I'm offended that you, whatever, so and so. You accuse me of that. Snapping. So there's no trial tomorrow because it's Juneteenth. And we're back on Thursday. So another short week. Half a day today. Honestly, I'm glad that the defense didn't go through full testimony with these two people. We would have been here all day, actually. But I get his strategy too, because it's like you're revealing your hand. Like the jury's not even here. The prosecution gets to, like, we're going to go through a full, all the testimony just so you know what's coming. And then you're going to prepare and talk to other experts and then come back to counter everything. That's what he kept mentioning, like biting the apple twice. Adam and Eve. Today was spicy. It was pretty spicy, and it was quick. It wasn't too bad. It was interesting. Voir dire. Day 27. We set up the stream now, so Thursday. At least that leaves us a little bit open. Oh, this shit I actually kind of wanted to do today too, as far as videos. Yeah, I agree, Stacy. She should have ended way earlier than she expected. They could have been there today and made some use of the day, you know. There was two things that I thought we could do later. I think later this afternoon. I'm not gonna say now, but a little bit later we'll come back. Let's see. There was two things I thought. Definitely this one. We'll come back to that. Oh. Okay. Yeah, we'll come back and do that, and we'll see what else happens. We could do a splash pad update too. Carly says the DOJ said there was no corruption. I believe the reason that there was an investigation. Let me read this that was posted. Why? This was a Twitter post by Yellow Cottage Tales. It says, why did the Fed launch an investigation into Karen Reed case? I think this solves the mystery. According to the state, the Feds launched their investigation in November 2022, but as I reported, messages show that Josh Levy was involved at least far back as August. In this clip, Jackson explains that he reported to the court on September 16, 2022, that the lead trooper, obviously Michael Proctor, was compromised because of connections to the Albert family. So I think we can piece together a timeline and likely the reason why the Feds got involved. Some people were saying that like the Feds are investigating the entire police station. I don't think that's that. I think people related to this case are being investigated. But it says, which are some cops, I guess. During the summer of 2022, private investigators for Karen Reed had turned up evidence of connections between Proctor and the Alberts. These connections were not deep. Proctor's sister is friends with Chris Albert's wife, Julie. So the defense team and Karen walked into the U.S. Attorney's office and met with the first attorney, now U.S. Attorney, Josh Levy. Hopefully time will tell if these are some personal connection between the parties that smoothed the way for this contact, or perhaps some other motive in the U.S. Attorney's office. But in any case, they seem to have successfully convinced them to help. Karen messaged her friend Natalie triumphantly that Levy was personally involved, even sending an employee chart to show Natalie how big a deal this was. Levy was in a very powerful position. Weeks later, the defense was ready to formally submit their complaint to the court. What part of the federal investigation began in November? Probably the grand jury subpoena process. 95% of the federal investigations begin on the ground and move up, just like you see in the TV show Law and Order. It begins with the police, then moves up with attorneys. But this was one of those weird cases where it actually began with the attorneys, and not just any attorney, but the top of the food chain. My sources tell me it literally began with Karen and her team walked into the U.S. Attorney's office. That's according to Karen herself. The FBI was brought in after, which also means that those agents went out under pressure of knowing this case was important to the boss. They essentially had motive to show there was some corruption here. Did this compromise their work? Maybe not, but maybe. There's indirect evidence that one of these agents, LF, had unusual communications with people that were essentially performing PR for Karen Reed. There's also evidence that another agent, SW, squashed the victim of TB named VH, who had a felony complaint.
The conflict. We have been saying since September 16th, 2022, in lengthy motions that we filed before this court and filed with the Commonwealth, there is a conflict. You're not investigating the conflict. That conflict was never described to the grand jurors.
So I feel like people kind of sometimes make it seem like, you know, these people saw like the investigation of Feds, like, oh my God, we have to, like, you know, like they just came in on their own because it was so crazy. No, it was requested. And that's why you see all these text messages and all this stuff from cops and all, you know, Proctor and Higgins and whatever else. But they were handed over all the information. according to these documents, they were handing over everything. It was the March 19, 2024. The defense indicated it was satisfied with the U.S. Attorney's representation. They had all relevant material information, and some of the federal documents were consistent with the Commonwealth's theory. So I don't know. All that to say, I don't know if they're going to be able to bring in this doctor, but we'll see. Were those experts? The other experts? Shit. I don't know how Lally's going to fight that. I'm very curious to see what they have to say. Lally. Let's see something. Young Thug. I'm so tired of y'all. Crazy motherfuckers. Young Thug.
Morning wash. So I may, depending upon what I decide to do,
legal conclusion or embarrassment.
Not much going on today. Young Thug. Young Thug. So, I don't know. We're going to see. We'll see what happens. The outcome of this, man. Yo, when the day comes, when the verdict comes back, oh my God, I'm going to be at the edge of my seat. Wow. Remember they got the
Today marks
submersible?
1 year since the Titan submersible began its doomed voyage to the bottom of the North Atlantic Ocean to explore the wreckage of the Titanic. The sub vanished, and after an intense search, authorities concluded the Titan imploded. OceanGate CEO Stockton Rush, who piloted the sub, was killed along with his...
One of these guys in the field, he was like, these people lied. You know how they were like, they have 96 hours to survive, or whatever it is, and we're all like, oh my God, and we're like streaming, and there's like the countdown timer where everybody's like, they said supposedly the first day that these people knew that there was an implosion because it was detected by the Navy, even though the Navy denies it. That shit was sitting on the bottom of the ocean the whole time.
4 fellow passengers. Carl Stanley, who was a friend of Stockton Rush, was an early passenger on that doomed sub just 4 years before the disaster. He's the CEO of Stanley Submarines and joins us now. Good morning.
Good morning.
Carl, I know this has to be a difficult day for you simply because you had a personal relationship with one of the victims and the man behind the Titan submersible. But can you tell us about your own deep sea trip inside that submersible and why it raised red flags for you?
We were warned, the passengers, that it was going to make sounds, but I wasn't really prepared for the intensity and frequency of the sounds that we heard. And
wow.
The more disturbing part was that it was still making sounds fairly close to the surface, which indicated to me that there was a permanent crushing, so to speak, of the hull, and that energy was being stored and then released. And I conveyed those thoughts to Stockton in a series of emails, and he ended up scrapping that hull and building a new one. I thought because of the emails that I had sent him, but from the Wired magazine piece that recently came out, first was 11 square foot area of visible damage to that hull, which is really shocking to me that that's what it took for him to change course, even that minor amount.
Carl, you talk about hearing sounds, and it's clear you are disappointed in the decisions that were made. Are you disappointed because he, too, like you, understood the science behind this and you wanted him to take more aggressive action? Describe that sound and talk about why you sound frustrated with the response and what he did or did not do as far as correcting the problem.
Be easy, I know.
At the time, I felt that making a new hull was a good solution, but it wasn't until a year ago that more facts started coming out. I think the Vanity Fair article was the first one that really opened my eyes to the extent that Stockton was capable of telling lies. And once you realize somebody is a liar, and it opens up questioning everything else that they said. And, you know, the more information that keeps coming out, the worse the story gets. And yeah.
Carl, talk about that sound. You said the sound. Was it like a popping? Can you hear it like collapsing on itself? What does that sound like to those of us who have never experienced anything like this?
It sounds like a gunshot or fireworks. It was,
wow,
you know, carbon fiber is a very strong material, and the pressures down there are so enormous that to start breaking it, you're releasing a tremendous amount of energy.
Carl, I have less than 30 seconds. I know you're working on your own technology in this space. What's next for you?
Well, I've been in business 26 years, taking tourists down into the deep sea here in Honduras. And I plan on continuing to do that for a good while.
Thanks for watching.
Business too, so I guess it's lucrative. You're making profits and stuff, taking people down there. Oh. All right, I guess I'm gonna get off for now for a little bit. I'll more than likely see you guys later. Describe the sound. Well, you know, when I heard him say cracking sound, I thought it was like just a little cracking, whatever. Not like it sounds like gunshots, bro. I'm like, you gotta bring the shit back up. You crazy? Oh, that's normal. Just relax. While you hear the gunshot popping sounds. Doosh, doosh, doosh. Oh, let's calm down. This is normal. All right, guys. I love you. See you guys later. Bloop, 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 bloop.